Does any member wish to speak? If not seeing you in the chat, Deputy, but you're in the chat, are you? You may well be. Maybe I can't see you. Deputy Southern.
Thank you, sir. And what I wish to do at this stage is to get some clarity into my thoughts and the Chamber's thoughts about where we're going with this document. And I leave silent any reaction to Deputy Ash. It gets the silence, wall of silence, I hope, that it deserved. The important factors to remember is that this proposition does not tie the minister's hands in any way whatsoever. What it does, it provides the Assembly with an opportunity to provide political approval for the Minister for Housing and Communities and the rest of the Council of Ministers to proceed with the implementation of some of the recommendations made in the Housing Policy Development Board in relation to rental housing, knowing in advance that the Assembly supports these recommendations. So it's enabling, it's permissive, and says, here's some starting points, do examine them, you may find them useful. And it kicks off with the statement, this is really a statement of the obvious now, which is that Jersey's housing market is not fit for purpose and will not improve without bold action and significant change from the status quo. Bold action and significant change is what it's after producing. And indeed, I believe that's what it has produced. I repeat again, without binding the minister at all. He can go where he wants. He could dismiss one of the ideas, two of the ideas, fairly early on in the process. There's no constriction in there at all, apart from it's time to get on with it, because as speaker after speaker has said, we've wrestled with this problem for decades now, and we don't appear to be getting anywhere with it. Maybe it's time for a properly researched, which this is, 2-year project, taking advice and looking at all the options and what might work and what not, what won't. That's if you like, on the plate. It then goes on page 5 of the proposition to look at the philosophy behind what's being proposed. Much discussion, it says, was had by members of the board about housing as a basic human right. Having a stable and affordable home is fundamental to our well-being. And I thank the Deputy Doublé for pointing that out to members, particularly for young people and babies. Fundamental to our well-being, both individually and collectively, because of the knock-on effect bad housing can have on educational and health outcomes. Education and health outcomes. Again, as yesterday, we're reminded how poor housing, bad housing, does nobody any good, and actually works to make our health and well-being worse than ever. When we're trying to deal with long-term health and well-being, anything less than good housing standards makes this worse. The recommendations, it says, are made with this philosophy in mind, and that philosophy is that good housing is a right, and that's what the government should be providing wherever possible. It then goes on in parts to discuss what I thought were fairly rational and relatively mild propositions for examination. So parts A and B talk about private rental housing and talk initially in 727 of tenancy terms, and says strengthening current legislation to create different leases with perhaps no fixed end date as a standard, and or extending the current requirements of 3 months for the landlord, 1 month for the tenant to tenancies of less than 5 years, suggesting a way forward by making tenancies longer term as a rule, and that makes sense to me. Security of tenure, strengthening current legislation to specify when landlords may or may not evict tenants, in effect ending no fault evictions, which increases the stability for tenants and reduces the need for costly unplanned moves. And finally, it says on tenants' rights, codifying best practice tenancy standards and responsibilities to landlords and tenants in legislation will promote greater tenants' rights by enabling tenants to, for example, redecorate properties and to keep pets. Again, making a parallel with ownership so that people feel, and indeed are, feeling treated equally. It then moves on to rent stabilisation. And the fact is, we've had this before. We have, as was pointed out in an excellent speech by Deputy Morell this morning, we have had a body which does exactly what it says in this sector, stabilises rents. Rent stabilisation, it says, is the prohibition of rent increases above a certain level. It exists in various forms throughout the United States of America and indeed in many parts of Europe. And as I say, we've had this before. The Rent Tribunal was set up exactly to do that, to look out for unnecessary, needless rises above inflation in the level of rents. Can this be justified? And would rule yea and nay and put limits on what the landlord could do. We've had this before. It's not rocket science. We could have it again if we chose to. It went on with details. Many tenants in Jersey will already have clauses preventing above inflation rent increases from being applied, as is recommended in the template tenancy promoted on the government website. This makes exactly the same approach, but makes it voluntary. That's the model. You use that model and you put in that limiting clause, not above inflation, then indeed you're meeting the terms that suggested here. We should examine further to see how we can make it work and indeed revive this moribund institution, which is still on the law book, but nobody ever goes and uses it anymore. Could that be? Could that be because the tenants don't want actually to challenge the landlord because they see a difference in power and control between the two? So I win my case, but maybe my landlord keeps me out next week. That should be avoided. And again, on 7.3.11, it comes back to develop the policy and supporting legislation, several steps should be undertaken. These include further research on the key policy areas. Permission, again, get on with it. Legislative process, and then establishing a rent commission or board. And some people have misinterpreted this board and said, oh no, it's about setting rents generally. But instead, that's not the case. To monitor this policy, so this is the paragraph in 7.3.21, rent commission or board. To monitor this policy, the government of Jersey should establish a rent commission or board that provides a body for tenants to go to and challenge rental increases and has the power to enforce landlords to adhere to rent stabilisation. So it's there not to make up arbitrary bureaucratic rules, but to respond to an appeal from a tenant that says, I've just seen my rent go up by whatever, 20% overnight. Can I object to it, please? I'll not have to face that burden. Is that fair? That's what the Commission is there to do, and replaces exactly what was done for decades under a previous law. So not dangerous, again, permissive. Do we investigate this? Do take a look at it, see if you can work out a scheme that can make this work. Again, as it used to in the old days, as it were. Don't often say the old days. It was rare for me. The proposer goes on, my colleague goes on, this is the least resource intensive method of monitoring rent stabilisation. It avoids the government of Jersey having to collect and manage rental data annually and empowers the tenants who are financially incentivised to monitor their rent. So make it available, make it there. The other thing, whilst I was thinking about what we're talking about when we talk about alternatives, is to return again to the 90%, 80% of private rents that we keep arguing and getting stuck on. And I'm taken back, and again, it's temps passé, to when I first set foot in this house 20 years ago. And how did we control our rents back then? Well, if you're on welfare, they said, they put in a figure on your welfare to say, and what we'll do is we'll charge you 25% of your income. So the argument around rental poverty and what's the right level, 90% or 80% of private market. In the old days, you'd go along your welfare board and they put a sum into the equation of, yes, you shouldn't be paying more than 25% of your rent, in rent of your income. And again, this doesn't say examine that in terms of what an individual household pays for rent and should pay for rent, but it does say, and let's look at the average rent rather than the private sector market rent when we're looking at how much we should be paying for our rent. And finally, in 7.59, to maintain investment in social housing, this would require a shift from the current revenue subsidy model, that social housing rents are subsidised through income support, in favour of a capital subsidy model. And again, Deputy Morell mentioned this, with subsidy in the development phase of social housing. This would require a detailed assessment, but the concept is to reduce social rents from 90% of market to a lower percentage, not defined, thereby saving Government of Jersey money in its income support expenditure. And I thank Deputy Morell for pointing out this anomaly that we have, whereby we've got a housing developer who siphons an enormous amount of money off to the Treasury in order to recycle it. And this is the thing that when we were doing the Great Housing Plan 5 years ago, we avoided discussing. It was mentioned and then it was ridden over. How we never addressed this leakage into the Treasury of money that really should be doing something else, like building decent homes. That's the reality. And we've missed that opportunity. And unless we mend it this time around, we are likely to see that continue and go on and on. Then says, oh yes, but listen to the words again, to maintain investment this would require a detailed assessment. So it's not prescriptive. It's saying you will need to do some more work than this, but here's the basis. Accept it, please, as what it is on the face of it, a permissive proposition. And here I've just written along, reduce social rents from 90% of the market to a lower percentage. And I've just heard the minister say today in his speech, well, that's my aim as well. I'm perfectly happy with that because that's my basis. I think we should be reducing the 90% to 80%. It's a matter of looking for a way to do it. So no coercion, no forcing, but a permissive, get on with it, please. Let's support this.
Thank you, Deputy. Does any other member wish to speak? Yes, Deputy Higgins.
Thank you, sir. It will be because I don't want to prolong the debate. However, I think it's important that every state's member actually states where they stand on the housing issue. And can I say that I have to agree that we do have a housing affordability crisis in Germany. We have done for many, many years, except in the last year or so, it's even worse. We know that many people are leaving the island because they can't afford to live here. And many of us have children who can't afford to buy a house here and may be forced to do the same thing. And that's totally unacceptable. A number of words have gone through my head while I was reading the proposition and also listening to the debate. I'm annoyed how long this has taken. I entered the States 14 years ago, and one of the things that I wanted to see changing at that time was the housing crisis we had then. And over the years, the States, as far as I'm concerned, have blown it. We've had different debates and repeated governments have failed islands, and it just got to end. Now, my fear with having to delay further with the... I'm sorry, sir, can you hear me? I'm getting an echo.
Well, we can just about hear you, Deputy Higgins. It's sometimes we lose a word. If you can improve things your end, I'm sure we'd be grateful, but we can just about follow what you're saying, I think is how I describe it.
Okay, well, hopefully it'll get a bit better. One of my fears is that if we decide to follow the Council of Ministers, we're going to get to another year of delay, and by the time of the next election, it still won't be sorted. Now, I like the Housing Minister, but when I asked a month ago what was happening about the digital property register for residential and commercial properties, he was very sympathetic when we spoke beforehand, but when I got the written answer, it's, oh, we'll be looking at it later on in the year. It's amazing how many ministers have got lots of things they're going to be looking at later on in the year. And that year is going to go very, very quickly. We will have an election and these things will be left undone. And all I can say is the islanders have the right to turf us all out because we failed to deliver on things that we promised in the past. So I will support this particular proposition because if it G's things up, tries to make things happen, then I'll support it. And any incremental change is better than no change at all. And just going back to the 90% rate for rental in the social area, I get very angry. I remember the debates at the time. It was a deliberate action on the part of government at that time, and I felt it was wrong then, and I believe it's still to be wrong. And therefore, as this is going towards trying to deal with that particular thing, I will support the proposition. And I hope other members will nail their colours to the mast and at least say whether they support this or don't, so that at least the public know where they stand. Thank you, sir.
Thank you, Deputy. If no other member wishes to speak, I call upon Senator Beswick to reply.
Thank you, sir, and can I thank all members who've taken part in this debate. I think the quality of contribution has improved as we went along, and it was Deputy Morell's speech that I think turned things round, because he put this back on track to a debate that was actually about the proposals I'm making. And I thought that his analysis of the social rent policy was absolutely spot on. I hope members were paying attention when he said that. One of my colleagues has suggested giving a wall of silence to Deputy Ash, and I'm afraid I'm too tempted to not do that. But actually, it's to try to be kind to him, because Deputy Ash, of course, spoke at the start of this debate and spoke against this proposition, described it as populist measures, which is a bit odd, because in fact he was a member of the Housing Policy Development Board that came up with these policies. And so I suppose that if he votes against this proposition, you could argue that it's actually a vote of no confidence against himself. And I just think he shouldn't be so hard on himself like that. And I would tell him that he will be forgiven if he wants to U-turn and vote in support of implementing the proposals that came about from a process which he was an invaluable member of and worked so hard towards. We'll all forgive him if he chooses to do that. And he had a bit of an irrelevant rant about party politics, but then it did get me thinking about another party when members of the government lined up to speak against this proposition. And I'm of course talking about the party from George Orwell's 1984, whose slogans were "War is peace, freedom is slavery, and ignorance is strength." It's a famous example of doublespeak here. And I say that because I still find, having listened to their contributions, that their in principle opposition to this proposition is simply incoherent. It doesn't make sense. It is a position where they're trying to dance on a needle and avoid saying whether they agree or disagree with these recommendations, at the same time as saying we have to abide by a process that is intended to build on these recommendations. And it just doesn't make sense. And I thought that the Constable of St John's point about treating propositions based on their merits rather than where they were coming from was a good point that I hope members will take heed on. But it is the case, I'm sad to say, that when listening to those contributions from members of the government, multiple things were said by them that are simply untrue. Not a matter of opinion, but just factually inaccurate, that cannot be left unchallenged, because it is not right for people to advance an argument using things that are untrue. And I'm not saying that that's intentional, but it can be as a result of negligence by simply not checking your facts adequately before making a point that you may well believe to be true, but you shouldn't be making it without checking. I counted at least 6 things that were said that I didn't think were accurate, so let's go through them in turn. The Assistant Chief Minister, Deputy of St Peter, expressed his concerns about landlords selling up and that reducing supply. Well, he should have checked that first, sir, because a Freedom of Information request came out not too long ago that has shown that, in fact, over the last few years, the numbers of landlords in Jersey is steadily increasing. Year on year, the number is going up. So his concerns are unfounded. It may well be the case that few of them are choosing to join his association, so he's not encountering them, but it is a fact that the number of landlords is increasing, not decreasing. And so his points about supply there are simply unfounded, and he should have checked that before making that point. Deputy Martin said a couple of things that were completely inaccurate as well. In referring to Part A of this proposition, she was saying that I'm asking us that every tenancy be an extended tenancy. No, sir, I'm not. I've specifically used the word standard practice rather than every, because there is a nuance there. If you have a standard practice, it is possible for you to have a non-standard practice as well that can be employed when particular criteria are met. So please, members, disregard that point. It is not accurate. That is not what you're being asked to sign up to, and that's clear in the wording of this. She then made a point which alluded to, I think she spoke before the Constable of St Saviour, I think, and the Constable of St Saviour made a similar point, but made it, I think, in a much better way. But Deputy Martin said that I was in the job for 3 years and produced nil point. Well, firstly, it was 2 years I was in the job for, but I won't nitpick on that. It's bizarre, though, to be told that I produced nil point when we are debating a proposition as a result of the Housing Policy Development Board that I was a fundamental part of. So please don't tell me I did nothing in office when you have the report on your table in front of you that demonstrates that that's simply not true. It's a bad faith claim to make, because it's just quite offensive, actually. Onto the Minister for Housing, who I think said 3 things that we can claim to be inaccurate, or 3 that I noticed anyway. The first one alludes to one that Deputy Martin made. He said that P31 comes about without full examination of the range of options. Again, sir, completely untrue, and members can see that with the appendix to the Housing Policy Development Board report, which has a long list of proposals that were all considered, all of the options. And if you check that list, you can see that lots of the options on there didn't make the final cut, because they were all considered, they were all examined, they were all put up against each other to see which would complement each other and which might conflict with each other before settling down on the final list of recommendations. That's in the Housing Policy Development Board. What he said there is untrue. He went on to say that the Housing Policy Development Board report does not say there should be open-ended tenancies. He said it doesn't specify that that's what it says. And so he's wrong. It does say that. You can go to section 727 in the report, which is the bit that addresses security of tenure, something which he wants to repeat in his housing action plan. And I can quote it. It says, this policy intervention consists of strengthening current legislation to create different leases with no fixed end date as standard. That, sir, I think says precisely what the Minister says it doesn't say. And I guess I'm kind of kicking myself that in the wording of my proposition for Part A, I paraphrased what the report says, when it seems actually I'd have been better off copying and pasting it and using the exact same wording. There's a lesson for the future. He also said that his housing action plan, part of the purpose of it is to negate the need to commission outside consultants in the future. Well, I suggest he looks under his own action 5B in his report, which itself says that they will be engaging a consultancy to do part of the work they're doing. So he was not right to say that, sir. And it's really disappointing that I have to issue so many corrections like that. Members ought to be better researched when they're trying to dismiss the work of another member who has brought a proposition forward in good faith. And may I remind those members that I brought this proposition before the Housing Minister published his housing action plan. So let's not pretend that I've attempted to disrupt any process. It's quite clear that I haven't. And in fact, I delayed this debate from the previous sitting so the Minister could do some more work on this. Something I have to say I regret doing. As I thought the purpose of that was for us to work together and find a way forward on this, not to give him an opportunity to get ready to oppose it all, which I think has not been a constructive way to do this. So looking at that action plan he's come up with, some members have spoken in support of that. Deputy of St Peter said he gave it an A-star rating, which immediately gets me worried about it. I would say, sir, that from this point in until the end of my closing speech, I will give way for any point of clarification or any point a member wishes to make if they are able to point to me in that report a specific tangible action which has a direct impact on people's access to housing and the affordability in it. And by that, I mean a clear action that says, here is a change we're going to implement, not, sir, another review of what change we might implement, not a plan to create another plan. I mean a clear proposal. There's only one that I can see in his report, and that's to abolish share transfer in future, which, as I've said, I agree with him on. Beyond that, there is nothing. It is weird, sir, that we can spend 2 years on a Housing Policy Development Board report to come up with tangible policy proposals, and then afterwards use that as the opportunity to undertake reviews. I would have thought, sir, it goes the other way round. So, you know, on that basis, sir, I think that the way forward he's outlined is a bit incoherent, and in actual fact, my proposition helps him, because it says up front, this work took place, it reached these conclusions, they're sensible conclusions. Yes, there's still some fine detail to work out on them, but the work that ought to take place now ought to be the work to come up with that fine detail. It's to consult on the format, it's to determine exactly how in practice this will work. It's not to go over old ground again, to look at these recommendations and say, oh, did they know what they were talking about? Did they get it right that time? Because that approach simply puts us in a cycle where we go round and round, where the next package of proposals the minister may come up with, a future government, or even this current States Assembly, if it's minded to, can say, no, we'd like you to look at all of this again. And then we end up no further forward. We end up with no concrete action to make life better for the people we represent. So what my proposition does is it says Housing Policy Development Board was on the right tracks. Now, using the resources you've got, using the team you've put together, which was also a Housing Policy Development Board recommendation. It seems to be one of the few that's been directly actioned, but still that's a good thing. To take that, what you've got, and get on with it with implementation. That, sir, I think is a much more constructive use of time and will get us to a better place much quicker, where we're improving affordability for housing, rather than going over old ground and going round in circles again, which is the real risk that we get with this. And I say to the minister that it will be embarrassing for him if he does the work he's proposing and arrives at the same conclusions as the Housing Policy Development Board after asking the Assembly to vote against the Housing Policy Development Board's recommendation. That ought to be a bit embarrassing if it comes to that. And so in trying to work out how to bring people together to agree on progress, I think I've learned a bit from the process of getting the landlord licensing scheme through, which we did yesterday. It's clear on that subject that in this assembly there are three camps. There's the members who are strongly in favour of landlord licensing and want an all singing, all dancing scheme. There's the camp who are completely against it, no matter what. And there's the camp who are sympathetic to the idea in principle, but just want to make sure the detail is fine. And the problem first time round is that none of those camps themselves formed a majority, but a coalition was essentially formed between those who don't want a landlord licensing scheme and those who are sympathetic to the idea but want better detail. And so you end up with nothing. What changed this time round is that Deputy Ward was able to swap the coalition and have it between those who want an all singing and all dancing licensing scheme, but who are prepared to compromise with those who are sympathetic to the principle but wanted a different type of detail to get the majority for progress. The reason I'm making that point, sir, and I hope members will recognise that appears to be how we managed to get progress on that particular action, that will be how we'll get progress for housing as well. If we vote against propositions because we think we don't have the detail we need up front, or you'd like to see particular consideration for this minor detail associated with it alongside it, if you use that as a reason to vote against, you're voting with the people who want no change come what may, and voting against those who are impatient for change and who want us to deliver it as soon as possible. And that's certainly the camp that I'm in. And I say to those members, that's why it takes so long to achieve anything in our political system. That's why it's taken us so long and so much money to get where we are with the hospital. That's why it's taken us over a year to deal with landlord licensing when it could have been dealt with differently. And that could well be exactly what happens this time round, where having spent 2 years and lots of money putting together a package of proposals, those who may want a little bit of extra detail or some certainty on some matters can inadvertently end up siding with those who actually just don't want anything to change, give them the majority, and then we end up with nothing afterwards. And so what I'm asking those members, and I won't try and name check all of them, but members like Deputy Morell, who I think made a really important series of points about social housing rents. He said he's more sceptical about the first two parts of the proposition, and fair enough, that's his view. And there are others as well who may want more detail on those other points. I asked them to vote for it this time round, because what you're not voting for with this proposition is from midnight tonight to slam in a whole bunch of new regulations right now that will disrupt the market that we have no idea what the consequences will be. That's not what the proposition asks you to do. It asks you to agree to the principle of improving security of tenure for tenants by making open-ended tenancy standard practice. There'll be some debate to be had on what the non-standard practice will look like, what criteria there'll have to be, how landlords will be able to take possession of their investments at the appropriate moments. It says we will introduce rent stabilisation. Again, there will be some fine detail to work out in terms of exactly what powers the Rent Commission has, whether it's a reworked version of the Rent Tribunal that we already have established in law, etc. That will be that work to do, and that will come back to the Assembly, and it will presumably go through a scrutiny process because it's an important piece of work. I would hope that it would be consulted amongst the public as to what that fine detail will look like, but voting in favour of it gives the Minister the mandate to go ahead and start doing that, and he can do that within the framework that he's already proposed in his action plan. It just gives greater clarity about what the direction of travel is, and we don't have any clarity about the direction of travel at this point, which is really disappointing. So on the social housing rents, I'm pleased to hear some of the comments made. Senator Valois, I know, has had very strong views about this and made those points at the time that the 90% policy was put forward. And there are questions about how much it will cost, and I think some really unhelpful points have been made there to confuse the issue here. I ask members, if you think that setting social housing rents so close to the market is a good thing to do, then by all means vote against that part of the proposition. If you think that 90% is a good way of calculating social housing rents, that it's a good deal for social housing tenants, then we simply don't agree and you can vote against this. But if, like me and other members, you think that actually something is not right about this, that it is not the most effective way of supporting low-income islanders in their housing, in delivering more social housing by giving access to the funding that Andium needs to go ahead and continue the work they're doing and to do that at the pace that we need so that we can address housing needs in the island, then please vote in favour of this part. You're not voting to starve the government budget of millions of pounds tomorrow. You're asking the government to come back in the government plan with a holistic package for how it intends to spend its money over the years after that, within which that will include a cut to social housing rents, which is funded. And so when it comes to the government plan debates, we spend days talking about the trade-offs. You know, we're going to take money from this place, we're going to put it here, we're going to increase the budget for this thing, we're going to prevent the cuts that's proposed over here. We spend days doing that work, and this will just be another one of those issues. When putting the government budget together, we'll say, right, we know that we're going to have to allow for a alternative return from Andium. We'll just factor that in somehow. It doesn't mean cuts to public services. It doesn't mean increases in tax. And as Deputy Ward, I think, has pointed out, we can find money when we need it. How many tens of millions have we spent on the hospital without a brick being laid? How much money are we spending? I'm sorry to make the point, but how much are we spending in golden handshakes that would have been completely avoidable in other circumstances. But when it comes to trying to improve our social housing system and make those on the lower incomes better off, suddenly where the money's coming from becomes something that's insurmountable. Something that's insurmountable to some members is quite a frustrating point. Deputy Doublé spoke about families and children, and I think really got to what this is about. This is about improving life for people. It's about saying to those families that a home is meant to be a place you feel safe in, it's meant to be yours, it's meant to be a special place to you where you create great memories, where you look after one another and where you can build your life from so that you can thrive. You can't do that if you're kicked out your home every year when your tenancy comes up. You can't do that if you're trapped in a home you can't move from and your landlord imposes unjustifiable rent increases knowing that you're stuck. And if you do have to move, all of the upheaval that comes with it, you know, working out your morning routine, getting to work, taking the kids to school, etc. And your children potentially moving away from their circle of friends who live nearby or living much further away from their school, etc. And what that means for after school clubs and all the rest of it. This has a real human impact. And that is the purpose of those propositions, to make life better for those people and to address the economic side of the housing crisis, which I really would be astounded if anybody seriously thought that we don't have a housing crisis. Obviously, Deputy Asher's speech being accepted for that comment there. So I don't really know what else more to say at this point, because I think we've heard some pretty spurious arguments against accepting recommendations from a government commissioned report, which the government has already got funding aside to implement, and which the government says that it wants to build upon. It is bizarre to be told to vote against those propositions when it should really be factored into what the government is trying to do now. So their opposition to it is bizarre. I'm going to ask members to please support all parts of this proposition, but I will take parts A and B together and parts B and C together. If you are absolutely adamant that we need change for social housing rents, but you'd like to see further work done on private sector, okay, I won't agree with that, but we'll understand it and give members the opportunity to vote accordingly there, or of course vice versa there. I ask members to vote because it says we're not going to spend time going over old ground. We're going to make a proactive decision on what change looks like and then set the government off with clear instructions on implementation and delivery. Then we'll stand ready to accept the final proposals when they come through later in the year, with the work having been done to build them, and not send a message out to the Council of Ministers that we actively oppose the recommendations of the Housing Policy Development Board, which I'm afraid will be the message that goes out if this proposition is rejected. And I think that will serve to do little more than cause more despair and helplessness over a subject that is causing real hardship and loss of hope for members of our community who we ought to be serving. So, sir, this proposition is extremely well thought out. It's the culmination of a long period of time where ministers, assistant ministers, non-executive members, lay members with experience and consulting with stakeholders has taken place to get a package of proposals that are coherent, tailored to the Jersey context, to deal with housing affordability in Jersey and deal with the housing affordability crisis that everyone out there on our island knows is real and knows is the case. So we can send that message to the government, get on with it. It's a constructive proposition. It seeks to be that way. It seeks to build on what is meant to be the government's position already. And so it's bizarre that they're opposing it, which I suspect is to do with the point that the Deputy of St John made, that it just doesn't fit with their way of doing things. But this assembly is what is sovereign over the island, not the government. So, sir, that's my closing remarks for this proposition. I call for the appel for parts A and B first.
Thank you, Senator. So for clarification, you want the appel on A and B first, and then the balance of the proposition. Is that right?
Yes, sir. I would think that part E probably becomes redundant if A and B and then C and D are rejected. So I would think A and B together, then C and D, and if either of those are accepted, then on to E.
Yes.
Sir, sorry, apologies.
Yes.
May I ask the Senator to consider splitting parts A and B? So,
It's a matter for the Senator, but Senator, you've been asked by Deputy Morrell to consider offering a separate vote on A and B. It's your proposition, though. It's a matter for you.
Sir, I think I've stated in my speech the risks with that. However, if Deputy Morrell is asking because of his conscience wanting to indicate his support one way or the other for those separately, then I'll accede to that request and say yes, let's have separate votes on those. But I think for C and D, they do really have to go together, so I wouldn't accept that for those two.
that's very kind, thanks.
So members are first voting on subparagraph A of the proposition, and in a moment the greffier will add a vote into the chat channel of the meeting. He has done so. I invite members to cast their votes.
Sorry, sir, it won't let me vote. It's asking me for a password.
In that case, you can vote in the chat if you wish to do so.
Yes, sir, thank you.
If all members have had the opportunity of casting their votes, then I invite the greffier to.
Sir,
Yes.
apologies, I'm interfering. I noticed the Connaught Upson Sabre has not made it into the chat yet, sir, in terms of the vote.
Well, there's been sufficient time and most members have cast their vote.
So can I raise a point of order, as Deputy Tadier? It's just to say that yesterday, because there were some technical issues as well for members, I see the constables managed to vote, so it's redundant now. It's just to say we did take some oral votes yesterday where people couldn't.
Yeah, I know. I had to do
I think
yesterday. Thank you very much.
Thank you. And I ask the greffier to close the voting. Part A has been rejected, 13 votes pour, 29 contra. Can I ask, does that include the votes in the chat or not? No. In addition, there were 4 votes contra. No. 3 votes contra in the chat.
May we have the 13, please, sir?
Yes.
The 13, those who voted pour were Senator Mezek, Deputy Ward, Constable St Helier, Deputy Lehegra, Deputy Pamplin, Constable of St Brelard, Deputy Tadier, Deputy Higgins, Deputy Alves, Deputy Southern, Senator Valois, Deputy Doublé, and the Deputy of St John. And in the chat, the votes in the chat were contra.
So could we have the contra, please, as well?
And
Yes.
those who voted contra were the constables of St Martin and St John, Deputy Aye, Deputy Young, Deputy of St Peter, Deputy of St Martin, Deputy Guida, Senator Gorst, Deputy Martin, Constable of Grouville, Senator Lafondre, Deputy Labby, Deputy Wickenden, Deputy of St Mary, Deputy of Grouville, Constable of St Mary, Deputy Truscott, Senator Pallett, Constable of Trinity, Deputy Pinnell, Deputy Gardner, Constable of St Lawrence, Senator Moore, Deputy of St Juan, Deputy Ash, Senator Farnham, Deputy Morrell, Deputy Lewis, and the Constable of St Juan.
I think you've missed me, sir.
No, we were in the chat, that's why.
Yes.
In the chat, those who voted contra were Deputy Masson, Senator Ferguson, and the Constable of St Saviour.
Yes, so we now move on to subparagraph B of the proposition. And in a moment, the greffier will add a vote into the chat channel of the meeting. He has done so, and I invite members to cast their votes on the link.
I'll vote in the chat, if I may, sir.
Yes. Cool.
That's not us.
Oh, we've reached 40. Yeah.
That's 40 on the chat and 5 on the.
We've reached 40 in the link.
Right. If all members have the opportunity of casting their votes, I ask the greffier to close the voting. The part B has been rejected. 13 votes poor on the link, plus 5 in the chat makes a total of 18 poor and 28 contra.
Can we have the 18 again, sir?
Members who voted poor were Senator Valois, Deputy Doublé, Deputy Alves, Deputy Higgins, Senator Mezek, Deputy Morrell, Deputy Lehegra, Constable of St Helier, Deputy Tadier, the Deputy of St John, Constable of St Martin, Deputy Ward, and the Constable of St Brelard. And in the chat, those who voted poor, Deputy Masson, Senator Mezek, Senator Ferguson, the Constable of St Saviour, and Deputy Southern.
That brings us to subparagraphs C and D of the proposition. Well, E, we did agree that E wouldn't be put if C and D were rejected. There wouldn't be a vote on either, would it? Because it has no function. But E,
Your mic is on, sir.
I know. Thank you for telling me that.
That's right.
Yes, Senator Mezek, we're going to put C, D, and E together, as there's no reason not to do so. So members are now voting on C, D, and E of the proposition. And I ask members to cast their vote on the link. Yes, Senator Mezek, can I explain? The view that the Greffier and I took was that now that A and B have been rejected, it's appropriate to include E with C and D. It simply avoids another vote on E if C and D are adopted by the Assembly. If all members have the opportunity of casting their votes, I ask the Greffier to close the voting. The proposition part C and D, find my results, appears to have been narrowly rejected with 20 votes for on the link, 21 votes contra, and 1 vote for in the chat, and I think 3 votes contra before the vote was closed, which makes a total of 21 votes for and 24 votes contra by my calculations.
Including the abstain, thank you.
And an abstention as well, yes.
Those who voted pour in the link: Senator Valois, Deputy Tadier, Senator Pallet, Deputy St Martin, Deputy Aye, Deputy Morel, Senator Moore, Deputy Ward, Deputy Gardner, Deputy Jubilee, Deputy Alves, Constable St Martin, Deputy Higgins, Deputy Lahegre, Senator Mezek, Constable of St Helier, Deputy Pamplin, the Deputy of St Mary, Deputy Southern, and the Deputy of St John. In the chat, the other vote pour was the Constable of St Saviour. Those who voted contre were the Constable of Greville, Constable of St John, Deputy Wickenden, Senator Lafondre, Deputy Guida, Deputy Ash, Deputy of St Juan, Deputy of St Peter, Deputy Lewis, Deputy Pennell, the Deputy of Greville, Deputy of Trinity, Constable of St Brelard, Constable of St Juan, Senator Farnham, Constable of St Lawrence, Constable of Trinity, Senator Gorst, Deputy Young, Deputy Truscott, Deputy Labby, and in the chat, the other votes contra were from Deputy Masson, Senator Ferguson, and the Constable of St Mary, and the abstention was Deputy Martin.
Accordingly, we move on to the next item of public business, the draft road traffic number 67 Jersey regulations, P37, lodged by the Minister for Infrastructure. The main respondent for this debate is the Chair of the Environment, Housing and Infrastructure Panel, Conrad St Brelard, and I ask the Greffier to read the citation.
The state draft road traffic number 67 Jersey regulations 2000. The states make these regulations under Order in Council of 26 December 1851 and Article 92 of the Road Traffic Jersey Law 1956.
Minister.
Thanks, sir. So the Department for Infrastructure, working with the Law Officers Department, the Comité de Connétable and the courts, have produced draft road traffic regulations to decriminalise parking enforcement. All parking offences will change to a civil enforcement process, except for leaving a vehicle on a road in a position likely to cause danger or obstruction, as the court can endorse a licence or seize the vehicle concerned for this offence. The proposal to decriminalise parking enforcement will provide a solution that eases the current burden on the Magistrates' Court and the parish, because under the current regulations, an unpaid parking infraction is resolved through a parish hall inquiry or a court summons. So the regulations presented to the Assembly amend the Road Traffic Law 1956, chiefly to enable the introduction of penalty charges in respect of parking contraventions in place of criminal proceedings. Regulation 2 makes a minor amendment to permit the parking of pedal cycles in designated cycle racks on footways. Regulation 3 inserts a new Article 68A into the law, enabling orders to provide for a penalty charge to be imposed in respect of certain parking offences defined in the article. A penalty charge is recoverable in proceedings in the Petty Debts Court whose decision is final. The person liable to pay the penalty charge is the person registered as the owner of the vehicle concerned. The detail of the penalty charge scheme is to be provided for by order. Finally, Regulation 4 names the regulations and provides for them to come into force 7 days after they are made. So these amendments to the road traffic regulation will allow for a formal appeal process, the appointment of an adjudicator for each enforcement authority to consider appeals, the reasons for which an appeal can be upheld, a maximum fine level which is set by the Minister by order. The responsibility for a parking penalty will lie with the registered owner of the vehicle concerned, and will set out in process for the Petty Debts Court to handle cases that become before it, and the reasons for upholding these in favour of the enforcement authority. So the application of fines collected remains unchanged. For the on-street, they are split equally between the roads account of the relevant parish and the state's general revenue, and for the car park fines to the benefit of the enforcement authority. There will be financial and manpower implications for the 12 parishes in reprinting the handwritten tickets, and they will need to appoint adjudicators to consider appeals. There is no manpower implications for the government, and changes to the car park administration system have been estimated at £15,000, shared between the Department for Infrastructure and the parish of St Helier. So in order to deal with the backlog of cases which were not able to be issued summonses due to the magistrates' courts due to COVID-19 restrictions, the new regulation will be applied retrospectively to all unpaid parking infractions which have not received a summons to the magistrates' court. So I will end by thanking the officers responsible for drafting these regulations and ask that states members support the decriminalisation of parking enforcement. So I make regulations.
Are the principals seconded?
Yes, sir.
There's a question for the Attorney General. Deputy Higgins.
Thank you, sir. Sorry. As people put their chat and it blocks out the microphone. Could I ask the Attorney General, this is, I think, the first piece of legislation since I've been in the States where the law has been made retrospective. I thought it was a principle that laws should not be retrospective.
Mr. Solicitor.
So the principle, which I think the deputy is thinking of, is the principle that the criminal law should not apply retrospectively to people's earlier conduct. That is not the effect of these regulations. In fact, it's quite the opposite. It is to say retrospectively that conduct which was criminal is no longer criminal and is to be dealt with by way of civil proceedings. There is nothing wrong in principle with that approach.
Okay, thank you very much.
Thank you. Connétable St Brelard.
I believe, sir, that
any change which reduces administrative processes has to be an improvement. Having been a centeneer, and as a consequence having a responsibility for making judgments regarding parking infractions, and I can assure members, sir, that I've heard most excuses under the sun for having incurred the disputed penalty. I think so. We shouldn't lose sight of the reasons penalty notices or parking tickets are issued. In an ideal world, they would be unnecessary and everyone would park in a reasonable manner for the time they needed to conduct their affairs without causing an obstruction so that life could continue as normal for others. Sadly, sir, this does not in practice occur, and people choose not to comply with regulations which have been put in place for the benefit of the community as a whole. There was an article, sir, in the Jersey Evening Post yesterday in which my parish administration were castigated for conducting their role in what I described as a professional manner, but the complainant considered unfair because parking tickets were issued, because there was a failure to comply with the regulations prevailing in the area in question. The reason the area is regulated, as are others, is because it's regularly abused by some vehicle owners who have been known to abandon vehicles for long periods of time to the prejudice of those who wish to use the adjacent facilities or commercial outlets. I make the point, sir, that parking control officers have to put up with all sorts of verbal abuse from individuals who simply refuse to comply with regulation, and sadly, that is the nature of the job. The proposed changes will, it seems to me, allow an appeal process, but I would be interested to know whether the person administering or adjudicating the appeal will have guidance to enable that process to be operated consistently throughout the parishes. And maybe, sir, in concluding, I could ask whether the Solicitor General will be in a position to clarify that position. Thank you, sir.
Thank you. Is that a question you want posed now?
Yes, please, sir.
Solicitor General, are you prepared to answer that question? You're able to answer that question?
I don't think I am able to. It must be a matter for each enforcement authority as to who they appoint as adjudicators, and the regulations don't stipulate what sorts of people would qualify. It seems to me it must be a matter for the parishes and the states in respect of their parking adjudicators to decide what training is given to assist those people. Whether or not there is a role for the law officers in offering assistance, I don't think I can say at the moment, but we would of course consider, if we were asked to do so, what help we could give.
Could I just briefly respond in asking whether the Solicitor General or the Law Officers Department would be prepared to assist in issuing guidelines in due course to assist? Thank you.
Is the Solicitor?
Perhaps I can consider that together with the Attorney General in due course.
I thank the Solicitor General, sir.
Thank you. Deputy Taddier.
Thank you, sir. If I could start with a question to the Solicitor General as well, is if I understand it correctly, as things currently stand under the current arrangements, that when a ticket is issued, it seems to say on it, I recall from the ones I've seen, that you've been issued a fine, but I'm not sure if it's called a fine. I think it's called a parking notice, and that you can make a voluntary payment. Can he clarify around that? Because I think he said it's currently a criminal matter, and we're changing it to a civil matter. I'm not sure that we should be doing that, and I'll talk about that perhaps in a moment. But just to find out that if it is a criminal matter, then why is it considered to be a voluntary payment? And why are we changing this law? Because I understand that there was also thought to be a problem with enforcement of it. So I don't know if you can help with any of those points.
So yes, I'll do my best. It is at the moment part of the criminal law, and it is so for this reason. And the Deputy is quite right. Tickets are issued, and they give a grace period in both parish parking and state parking. They give a grace period to the recipient. to pay voluntarily a lesser sum than the ticket carries on its face. If they fail to pay within the deadline that they are given, two things follow. First of all, for a parish ticket, they get a letter inviting them to attend the parish hall inquiry. If they either fail to attend the inquiry or they do and they still refuse to pay, the next step is that the parish issues a summons for that person to attend the magistrate's court. The same process applies slightly truncatedly for states parking in that it doesn't go to a parish hall inquiry as a second opportunity. A further period of time is given to the recipient in which to pay the penalty, failing which a summons is issued for that person to attend the magistrate's court. At that point, they are within the criminal justice system, and the magistrate will determine whether the ticket was rightly issued, and if it was, will impose a fine on the recipient for failing to pay. So that's the way the system works at the moment, and that is assuredly a criminal law process once it's in the court.
Thank you, sir. Well, I thank the Solicitor General for his points there. My concern is this: I have slightly mixed feelings on this, and the first is that I'm concerned that we're moving away from a criminal offence, albeit one which is quite rightly very low down on the level of what can be considered criminality, to a civil offence. And the reason for that is because we're still dealing with public bodies here. We're dealing with not parking on private land, but we're dealing with parking on either government, public land or municipal parish land. And it seems to me that if there is an infraction, logically it would seem that there should still be some statutory law to back that up and processes by which to follow that, even if it means that there might be different ways of dealing with the fines, such as on the spot fines or whatever. That said, I can also see that we might not want to unnecessarily criminalise people, and it's been a bugbear of mine for a long time. Not that I live in St Helier or represent St Helier, but it seems to me that the cost of motoring for people who live predominantly in St Helier, but it could apply to some of the other urban or suburban parishes and hubs, is that they pay a lot more, because you're much more likely to incur a parking fine, not because you're a criminal, but just because the way life exists. 5 minutes parking somewhere where you nip into a shop and you'll occasionally get a fine is probably much less likely to happen in the rural areas, if indeed there is any parking control in the rural areas where you're allowed to just park willy-nilly on main roads and everyone just gets on with it. So I can see, I do have mixed feelings about this, and I did have the same alarm bells that rang when I heard it was being applied retrospectively, and I'm not convinced that just because we're moving from criminality to a civil offence, that it shouldn't be the case that the old rules apply. You should really be have recourse and be judged on the law that was in place at the time when the offence was committed. And if it was criminal back then I think the same method of resolving those disputes should be available to anyone who's been in receipt of a ticket. In fact, what we should be doing is just quashing all of those tickets, I think, that have been issued and not been dealt with yet, because it's completely wrong to do it under a completely new apparatus. Justice delayed is justice denied, and because we're not dealing with or talking about very serious issues here, although of course they can be annoying and I'm not justifying them in any way, I think the right thing to do would be to quash those completely, and so I'm not sure that I can support this. Lastly, I would say that it's really important that we do have respect for anyone who's administering parking fines, but I would say that community traffic wardens, it's really important that they also operate by consent in the community, and I think that they're most respected when they act in an even-handed manner And so that surely in areas where parking is effectively free with a disc, but somebody is nearby and forgets to put one out, maybe because historically it's not been policed, and they are nearby and they can keep an eye on their car. It seems to me that the best policing often involves discretion, and sensible outcomes. And I know that the current new traffic warden in St. Brelard, who she seems to be getting on very well with her work, I think is somebody who will exercise common sense in the role, and I look forward to, and I'm sure we welcome her as a parish in that new role, sir. Thank you.
Thank you, Deputy. Deputy Ward.
Thank you, sir. Really, I have a question, and it may well be for the Solicitor General, and I'm not a lawyer, so I'm not entirely sure. But my question is, in this move from criminal to civil law, does it open the door for a wider range of people who can administer tickets or penalty notices? So, for example, and I'd ask the Minister, and perhaps I don't know if the Solicitor General has an opinion on this or can advise, whether it opens the door for outsourcing of this to private companies who will, or an entrepreneur will say, look, I'll police this area for you because now I can administer a ticket which is for a civil offence, not a criminal offence, and I'll just take a cut of the proceeds from the fines, because that will change the nature of what's going on, and we'll lose that community spirit, and we've seen it in some areas in other places. What happens regards, could this extend to wheel clamping or private individuals, for example, who feel that somebody is parking inappropriately? I just wonder whether this makes any change in the law as to who can administer these fines, because if there is a subsequent effects that we've not thought of here, if there's a knock-on impact, then I think we need to look at this very, very carefully. So I think we need to look at that as well, sir. And if I'm way off the point there, then to be honest, I'll be quite pleased, because then I won't have anything to worry about. Thank you, sir.
Thank you. Deputy St Mary.
Thank you, sir. I note that the responsibility for parking penalty will lie with the registered owner of the vehicle concerned, which is the obvious answer. In view of the number of hire cars we have on the island, will the Minister be introducing any particular system to ensure that users of those hire cars will pay their just dues before they leave the island? Thank you, sir.
Thank you. Conatab of St Helier.
Thank you, sir. I haven't got my volume on. I don't know why it's doing that. Oh, mic off.
You put the microphone.
Thank you, sir. Of course, I welcome the proposals that have been worked up by the Minister in conjunction with the parish of St Helier. However, I do think it's a pity that once again, and this very much goes back to question time yesterday, we're seeing a measure that is being introduced as an ad hoc measure with no strategy behind it. The Minister has promised a parking strategy, and this new system of fining people who fall foul of parking regulations really should have been part of a strategy. And then I suspect that a lot of the questions that have already been asked about the measure would have been unnecessary. I'd also like to take a slightly different view, sir, from the views expressed by the Constable of St Brelard about people who incur parking fines. In my experience, the vast majority of people who incur parking fines do not set out deliberately to flout the law, but they find themselves in many cases unable to comply with it, often due to the complexity of the parking arrangements that apply in a particular street, or indeed personal circumstances that prevent their returning to their vehicle by the time they intended to. I have lost count of the number of people who have come to the town hall in those days when the constable could cancel a parking fine in floods of tears, having had a shopping trip or a trip to a restaurant ruined by finding a parking fine on their windscreen. I regard parking fines as something that in an ideal world, as another speaker has said, we wouldn't have to deal with. And I hope that with the increasing use of digital technology and online systems, that we will indeed move to a time when people are far less likely to have, as I say, their trips to town or to other parts of the island spoilt by what is often a fine of significant proportions for many people who struggle to pay them. So while I welcome this, so I do hope that, as I say, in time we will have a strategy from the Minister which will make parking far less of a trial, and indeed, as far as the capital of the island is concerned, increase the attractiveness of people coming to town for whatever reason. Thank you, sir.
Thank you, Conrad. Does any other member wish to speak on the principles? If not, I invite the Minister to reply.
Thank you, sir. And I thank all members who responded. May I also thank the Solicitor General, who's actually fielded most of my questions. Deputy Higgins mentioned retrospective fines, not really in my domain, and I thank the Solicitor General for fielding that one. The Constable's umbrella, well, nobody likes a ticket. I think we're all on the same page there. Guidelines have actually been issued to all parish secretaries. I believe it came through the parish, it came through the secretary of the Comité de Connotables. So I believe all that's been done already. Deputy Tadye, criminal versus civil, it was made voluntary a while ago. People were invited to send in their parking infraction fines voluntarily to avoid a parish hall inquiry. I believe that was just the interim measure there. Deputy Ward, privatisation, no, that's not going to happen. Not in my book at all. The states of Jersey, under my department infrastructure, we have our parking control officers. Parish of St Helier has their own wardens. St Bernard have their wardens. St Saviour has wardens, and the parish of St Martin have their own wardens. Their wardens also help out very well actually during school traffic coming and going. The Deputy of St Mary mentioned hire cars. Yes, that can be tracked through the hire car companies. They have the people's names and address should they leave the island without paying for a infraction which they may have incurred. And likewise, if it's a private vehicle, say with a UK registration, that registration can then be tracked through the police department to their homes in the UK or elsewhere. Constable of St Helier, I repeat again, nobody likes to receive a parking ticket. It does ruin people's day. We do have facilities in Sand Street Car Park, the ANPR, the automatic number plate registration. So that's, you can go in and park for as long as you like. And if you meet someone in town, you can have a coffee, you don't have to rush back. And maybe we should roll that out even more as funds allowed to other car parks. Also, modern technology was mentioned, that you can do your tickets by phone, sort of a parking approval tickets, that is, by phone, and so on and so forth. I think that's about it, sir. I thank members for their questions.
Minister, there's a point of clarification from Deputy Ward. Are you prepared to accept that?
Certainly, sir.
Thank you, sir, and I thank the Minister. What it was, I think my question, my own fault, sir. I apologise to the Minister. I should have been clearer in what I was asking. I think I was thinking on my feet, actually. I just wonder whether the move from criminal to civil makes it more likely or there's more of an ability to have private companies or entrepreneurs take over the ticketing system. Or whether it's the role of those parish wardens is, if you like, linked to the law, that they are the people employed by parishes or government that can only issue those tickets. I.e., does it make it easier? That was my question. It may be one for the Solicitor General, and I accept if the Minister wants to pass that on, because I don't know the answer. So thank you, sir.
Indeed, I thank the Deputy for the question, sir. The 12 parishes are the parochial authorities. It is a matter for them. They will have their own adjudicator for each parish. We will probably share one in St Helier between obviously the states and the parish of St Helier. I think fine details are being worked out, but I'm not a great believer in privatisation. That might surprise the deputy, but this will be done in-house. Thanks. I'm not sure if the Solicitor General would like to comment on that, sir.
Yeah, sorry, sir. It was whether the change in the law makes that more permissible, I suppose is the word. Thank you, sir.
Mr. Solicitor, can you respond to this question?
So before the solicitor does that, can I ask a point of order, Deputy Tadyer?
Yes.
Just because I'm a stickler for process, and is it in order to ask the Solicitor General or the Attorney General questions once the debate has finished and the Minister's summing up?
First reading.
Yeah.
I think in the particular context, it is particularly the context, which is that Deputy Ward originally asked this as a question of the Minister or the Solicitor. So without laying down any general rule in the context of this particular question, I think it is proper. Yes, Mr. Solicitor, do you have a response to the question that Deputy Ward has asked about the scope of the legislation and the opportunity for private contractors to become involved in due course?
Yes, I don't see this legislation as opening as itself allowing that to happen. It's open to any legislature, forgive me, in this area to legislate to deregulate the enforcement of parking. Whether there was any wish or desire to do that it seems to me a purely political question for this assembly.
Okay, thank you, sir.
Thank you. And in a moment, the greffier will add a vote into the chat channel of this meeting. He has done so, and the vote on the principles is now open, and I invite members to cast their votes. Thank you. If all members have the opportunity of casting their votes, I ask the greffier to close the voting. The principles have been adopted. 36 votes pour on the link and 4 in the chat, making 40 votes pour and 1 vote contra. Forgive me.
Could we have the 1, please?
The vote contra was Deputy Tadyer.
Conatable and Brillard, does the Environment, Housing and Infrastructure panel wish to scrutinise this matter?
No, thank you, sir.
Minister, how do you propose to deal with the regulations in second reading? En bloc? Deputy Lewis? Deputy Lewis, we can't hear you. Can you hear us?
There we go. So sorry, my fault.
Yes.
May I just add prior to the vote, prior to the second reading, that people can be pursued who leave the island without paying parking infractions by Treasury departments, and also regarding nominated people, Ports of Jersey also issue their own ticket, sir. Just thought I'd
Yes.
clarify that, sir.
Do you wish to propose the regulations in second reading?
Indeed, thank you, sir.
Do you wish to say any more about the regulations?
I thank members for their questions and their understanding, sir, and make regulations.
Are the regulations seconded?
Yes, sir.
Thank you. Does anyone wish to speak on the regulations? Deputy Tadia.
Thank you. So it's to ask the point that the Minister just made about saying that the Treasury can pursue people who leave the island, but that presumably won't be the case anymore, will it? If these become civil matters, it wouldn't be right for the Treasury to then pursue somebody who has left the island. So how would that process work in a civil context? And can the Minister explain whether there will be because currently, obviously, parishes hold information about, and the states holds information about people, but if it's no longer a states or parish matter, but a civil matter, is it correct? Is it right that that kind of information that has been stored and used and obtained for different purposes be used to resolve civil matters from a data protection point of view? And if not, is it right that that information will be passed on to an intermediary, like a debt collection agency, to pursue the debts on their behalf? And I guess the other point that I'm concerned about is that in moving from a criminal to a civil matter, and I think it does relate to these regulations in particular that we're passing, is that I suppose it's a fundamental change in the process whereby you could have had your day in court, so to speak, either at the parish hall, which I know isn't a court, to plead your case before a centenaire, or to take it to a magistrate's court to get a hearing. That's no longer the case. It becomes a civil matter. Presumably, a petty debts means that there's a fee to be paid by the person pursuing that. I just think this is a complete change in administration, and I'm not sure that I think there are going to be unintended consequences that we're going to find out about, that we don't know about now, of course.
Thank you, Deputy. Sorry, it's not your turn yet, Minister.
Oh, sorry.
Senator Pallett.
Senator Pallett.
Thank you, sir. I've just got a question. I don't know if it's one for the Minister or actually one for the Attorney General, but in Article 3, where Article 68A is inserted in 2, it says the penalty charge is recoverable as a debt due to the enforcement authority by proceedings instituted in the Petty Debts Court, and despite, and that's the word, and despite Article 3 of the Petty Debts Court, blah, 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 the decision of the court in such proceedings is final. That would suggest that the proceedings in the Petty Debts Court usually are not final. Is that actually correct? And why is the decision being taken that these infringements, the decision of the court in this particular case, will be final in the Petty Debts Court?
Is that a question for the Solicitor General or the Minister?
Probably the Solicitor General, I would have thought, sir.
Yes. Solicitor General, do you want to respond to that question?
Yes, the Article 3 of the Petty Debts Court affords a right of appeal from decisions of the Petty Debts Court to the Royal Court. Jurisdiction of the Petty Debts Court financially is I think, quite significant. I think from memory, I'd have to look at it. I think it's up to claims of up to £30,000. The Petty Debts Court has jurisdiction. One would anticipate that one would anticipate that all actions under these regulations to recover parking penalties would be very modest in total. And so I think for pragmatic reasons, the view has been taken on policy grounds, I would think, that it does not make sense to afford a right of appeal from the Petty Debts Court on a parking matter to the Royal Court, because it would seem to be excessive and not in the public interest. That, I assume, is the thinking, but that certainly is the effect of it.
Sir, could I just ask whether that applies to any other debt in the Petty Debts Court, because I know people take people to the Petty Debts Court for quite small amounts. So I just wondered, I understand the pragmatic view and the number of potential cases that would end up in the Petty Debts Court, but for me, this is setting a precedent.
Mr. Solicitor, any response to that question?
So yes, the answer is no, it doesn't affect other rights of appeal under Article 3 of the Petty Debts Court. This is a singular carve out of that provision solely for these purposes.
Does that answer your question, Senator? Are you going to make a speech as well, or
No, sir. I thank the attorney for the Solicitor General for his answer.
Thank you. Deputy Talia, you've got a question as well for the Solicitor General.
Yeah, thank you, sir. It follows on from that question. Thank the Senator Pallett for pointing out that fundamental issue. There was presumably a human rights audit done on this, and it's the right to appeal it to a higher court, even in a civil matter like this, is, I think, fundamental, and this is a fundamental shift from that policy. So what were the comments and advice given to the Minister in bringing forward this? Or I don't know what you can say, the Attorney General, Solicitor General can say, but there must have been human rights considerations around that in order for that to be considered proportionate.
Yes, I can't speak to the advice that was given, but what I will observe is this, that the system, it's not right to say there is no right of appeal. Of course, the adjudicator is there before any civil proceedings are commenced to consider any appeal against the issuing of the penalty. It's only after that that the prospect of a civil proceedings to enforce a debt would arise. So it's not right to say there's no a review by way of appeal. There is. It simply happens at the beginning of the process, and it doesn't happen at the end of the process. It's not unreasonable, in my view, to build into a system which is dealing with extremely minor matters a pragmatic approach to the use of court time, because of course there is a wider public interest to be served in ensuring that our courts are not, as it were, weighed down with dealing with matters which perhaps lack the gravity to justify that approach. But I think that the safeguard is there in the adjudication provision, and there is further safeguard actually in the Petty Debts Court itself. If one looks at the order, the ministerial order that would be made on the back of these regulations, it provides, if I can find it, at paragraph 12, article 12, forgive me, of the proposed order, that the Petty Debts Court must give judgment in favour of the enforcement authority if it's satisfied of a number of conditions that are met. But it goes on to say that the penalty charge notice, if it's been challenged to the adjudicator, or if it wasn't challenged, but the court finds reason for not giving judgment in favour of the enforcement authority, the court can find that it won't give judgment. So it's not open and shut in the Petty Debts Court. There is scope for the Petty Debts Court to say to the enforcement authority, well, I'm finding against you and I won't give you judgment.
Thank you. The further question from Senator Pallett. Senator Pallett.
Thank you, sir. I don't know if it's one that the Solicitor General can answer, but he mentions that there's obviously appeal to an adjudicator. There's nothing within the actual law itself that mentions the adjudicator and the role that adjudicator plays within the process. Is that something that should be or would be better off within the regulations? Because there's nothing in regulations that show how that regime will work. And I'm just wondering where that will sit so we understand how people will be treated fairly.
Yes, the provision for what I called an appeal lies in Article 11 of the proposed ministerial order. A person who's received a penalty charge notice may challenge it at any time during the payment period in writing to the enforcement authority on the grounds that, and then it lists a number of bases upon which the ticket can be challenged. The question as to whether that would be better in the regulations or in the order, I think, is perhaps somewhat moot. It's going to be made law by virtue of the order, and that will have the force of law. I hope that's helpful.
Thank you, sir. Thank you, Solicitor General.
Thank you. A separate question from Deputy Tadier, the Solicitor General. Deputy Tadier.
Thank you, sir. And so the context of this question is that if there's no appeal mechanism, that one of the things that an appeal mechanism offers, it isn't just simply to disagree with a decision, but it also acts as a check and balance to determine whether or not the law is being interpreted correctly, and if there's a complaint around that. So my question is, in the absence of an appeal mechanism from that final decision of the Petty Debts Court, if either party were unhappy with the decision, not just because it didn't go in their favour, but for some kind of technical reason, which might normally give rise to an appeal, are they open to a complaints mechanism? And would the complaints mechanism not possibly end up being used as an ersatz for the absence of an appeal mechanism being in place?
No, I don't see that being the case. The decision of the Petty Debts Court is expressed to be final. No provision is made for a complaint mechanism, and it would be unusual for there to be indeed any complaints mechanism in place to deal with the final disposal of a case by a final court of law. So no, I can't see that there's anything in the deputy's point, I'm afraid.
So I do have a supplementary, because it seems to me that at the moment, if you disagree on a technical point, if you think, for example, the magistrate has misinterpreted the law and missed a key piece of misinterpreted the law, and that's why they come up with the wrong decision, maybe because one party or another thinks that they're not competent, and so it actually relates to a concern, therefore, with the magistrate. There's presumably a complaints mechanism in place generally, isn't there? So if you have concerns about the conduct of a magistrate, is that not open to the individual and either party to pursue that mechanism?
The complaints procedures that exist in respect of the island's judiciary do not relate to the decisions that they make as judges sitting in cases. They relate to the general conduct of a judge, which may bring the judiciary into disrepute. So no, that would not serve as a mechanism by which to effectively review or appeal the decision of the Petty Debts Court under Article 12 of the Ministerial Order.
Thank you. Conatable St. 1.
Thank you, sir. I'm not entirely sure. I lost track of what questions have been answered and asked and answered, but if it's any help, in terms of collection of civil debts, the parishes already do this through Petty Debts Courts and through collections agencies in relation to unpaid rates. So this is not an unfamiliar procedure to parishes. And indeed, in answer to the point about GDPR, this again would be entirely GDPR compliant because the data is being used for the purpose for which it was collected, i.e. the enforcement of a parking penalty. I hope that's helpful, sir.
Thank you. Does any other member wish to speak on the regulations in second reading? If not, I call upon the Minister to reply. Minister.
Thank you, sir. And again, I'm obliged to the Solicitor General for his assistance. Basically, there's a lots of symmetries which are what's happening at the moment. That if one is unlucky enough to receive a parking ticket at the moment, one can go to a parish hall inquiry see the centennier or ventenier and plead their case, but one would just be doing that to an adjudicator in future, and each parish would have their own adjudicator. It only becomes a civil debt if the debt is unresolved after a period of time. Magistrates, well, we would only go to the magistrates in an extreme case, I think, with a string of tickets. And if one's not happy with the magistrates, well, then I'm not sure if that goes to the Law Society or the Attorney General, but there's always recourse. The whole process has been audited by the audit. There's a human rights audit's been done, and that has been cleared. So it is human rights compliant, and the order follows the regulations. Constable St. Juan, I'm obliged for his comments, but it has been gone through very, very carefully. I'm very grateful to officers and to infrastructure staff for all their hard work on this, and I make the regulations reading.
In a moment, the graphier will place a vote into the chat channel of this meeting.
Sir, Senator Pallett, could I just ask that Article 3 is taken separately? Please.
Minister, there's a request that regulation.
Yes, sir. I'm from that. Yeah, I don't have a problem with that, sir. Absolutely.
Yes.
Quite content with that.
You're content with that, yes. So we'll vote on.
It's irrelevant, sir, whether he's content.
Are you content with that, Minister? I think you said you were.
Indeed, I'm content with that, sir. Yes, absolutely.
So, the point of order is, Deputy Tadia, it's irrelevant whether the minister is content. I mean, Senator Pallett has an absolute right to ask for.
I mean, the House of Members, sir, if they were to take it separately, I'm more than happy with that.
It's being taken separately.
Okay.
So we'll first vote on regulations 1, 2, and 4. All right. We'll deal with regulations 1 and 2 first, and in a moment the graphier will put a link in the chat. Ask members to cast their votes on regulations 1 and 2 in the chat. I'll throw the link for the chat. Ask the graphier to close the voting. Regulations 1 and 2 have been adopted unanimously in second reading. 38 votes for on the link and 3 in the chat, making a total of 41 votes for and no votes contra. Now move on to regulation 3. In a moment, the graphier will put a link in the chat. He has done so, and I invite members to cast their votes.
Set of 5.
If all members have the opportunity of casting their votes, I ask the greffier to close the voting. And Regulation 3 has been adopted in second reading at 33 votes for on the link and 3 in the chat, making a total of 36 votes for and 2 votes contra. Finally, Regulation 4. I invite the greffier to place a link in the chat. He's done so, and accordingly I invite members to cast their votes in respect to Regulation 4 in second reading. If all members have the opportunity of casting their votes, I ask the greffier to close the voting. The fourth regulation has been adopted unanimously in second reading. 36 votes for and no votes contra on the link, and certainly 3 votes on the chat. One may have come in too late. Minister, do you wish to propose the matter in third reading?
I do, sir, and may I thank again the Solicitor General for his kind advice, members for their questions, and indeed I'd like to thank the Law Officers Department and my own infrastructure officers who worked very hard on these regulations, sir. And with that, I make the regulation in third reading.
Thank you. Are the regulations seconded in third reading?
Yes, sir.
Does any member wish to speak in third reading? Yes, Senator Pallett.
So just very briefly, because I'm conscious of the time, it's just a request of the Minister that when he brings regulations or anything of this type to the Assembly, that he provides a report, an explanatory note that fully sets out what he's intending to do. I'm sorry, but I found both the report and the explanatory note not acceptable, not inclusive enough of all the information that states members might ask, and then we end up having to prize information out of the Minister. So I could just ask him in future that I know his officers have put a lot of work into this, but maybe they should put a little bit more work into the explanatory note in the report. Thank you, sir.
Thank you, Senator. Deputy Talia.
Thanks, sir. So the reason that I was happy to support and vote in the same way as Senator Pallett is not because we've formed a breakaway coalition of our two party fringe members, but it's because I think even on debates like this, which seem to be relatively minor and straightforward, I think that's often when things can get passed, which can set precedents. And I think there is a fundamental issue here about not having that appeal mechanism in the effectively in the petty debts court, which will be presided over by magistrates, because as I've said, and I guess it touches on what I've been trying to get answers from a different minister about under a different law, but which is administered in the petty debts court, and that is the residential tenancy law. And the point of an appeal mechanism is that appeals don't just help shape the interpretation of the law, whatever law that might be, or civil procedures, but it actually is a safeguarding mechanism, because it can flag up issues, as I've said or inferred in my earlier speech, implied in my earlier speech, where the law isn't being interpreted correctly. And that check and balance between the two bodies of the judiciary and the parliament, I think are absolutely fundamental. And we've heard that there isn't really a complaints mechanism either that can be applied if you think that a magistrate has drawn the wrong conclusion, because that would normally be dealt through an appeals mechanism. So the idea that we're going to front load the appeal, unfortunately, doesn't make any sense to me at all. You don't front load an appeal mechanism. An appeal ultimately happens at the end, and to say that the petty debts court, who is administering the debts collection adjudication, is also the final court is a dangerous precedent, I think, for that reason. In my experience, there has been, and there still is, an asymmetry of power when it comes to being pursued in court, and especially when it comes to these civil matters. And I've got serious concerns. So with my human rights hat on, and still as chairman of the Jersey Human Rights Group, I did want to thank Senator Pallett for flagging that up, like something I might not have picked up otherwise. And I know that others won't necessarily feel the same, or they'll feel that the question of proportion is more important than the actual technicality of this. But for me, I think it is an important issue, and it's a step too far, which is why I won't be supporting this in the third reading.
Thank you, Deputy. Does any of them wish to speak in third reading? If not, I call upon the Minister to reply. Minister.
Yes, indeed. Thank you, sir. And I, of course, would defend the senators and deputies' right to bring this to our attention. As I've mentioned previously, this has had a full audit, and it is human rights compliant. I believe the same checks and balances are in place, or very similar. Instead of appealing to a centenaire, one would appeal to an adjudicator, and petty debts do not become involved unless the debt is unpaid, like any other debt one may incur in a shops or any other transactions. The petty debts only get involved if the debt is unresolved ultimately. But with that, sir, I make regulation.
Thank you. In a moment, the greffier will place a link in the chat in respect of the vote on these regulations in third reading. He has done so, and I invite members to cast their votes. If all members have the opportunity for casting their votes, I invite the greffier to close the voting. And I can announce that the regulations have been adopted in third reading. On the link, 36 votes pour, 2 votes contra, and a number of votes in the chat at least 4 which were cast before the vote was closed. The next item is the draft road traffic number 68 Jersey regulations lodged by the Minister for Infrastructure. The main respondent for this debate is the Chair of the Environment, Housing and Infrastructure panel, Conatable St Brelade, and I invite the greffier to read the citation.
Draft road traffic number 68 Jersey regulations 2000. The states make these regulations under the Order in Council of 26 December 1851 and Article 92 of the Road Traffic Jersey Law 1956.
Minister.
Thank you, sir. And my apologies to members in advance that this is another very wordy one, but this is something that's already been approved on Proposition P30. So if approved, if approved by the Assembly, these draft traffic regulations implemented the state's decision on Proposition P30 from 2019 to provide CATs additional protection when involved in road traffic accidents. These draft regulations would amend the duty on a driver of a vehicle to report if the vehicle is involved in a road accident by including a new duty on a driver to report when a motor vehicle hits a CAT. So Regulation 2 substitute existing Article 52 of the Road Traffic Jersey Law 1956. Under the new article, the driver of a motor vehicle who reasonably believes that a cat in the road has been struck by the vehicle must stop as soon as it is safe to do so. The driver must then notify either a person who is responsible for caring for the cat or a person or body specified in the Jersey Highway Code. The driver must state when the cat was struck and where the driver last saw the cat. Under the Highway Code, the driver of a vehicle which hits a cat must report the accident to the JSPCA. Failure to comply with the duty in the new article is an offence punishable with a maximum fine of £10,000. Under the new article, where an accident is reported to the JSPCA must keep a record of the information given and make that available to any person who seems to have reasonable grounds for requiring it. So the opportunity has also been taken to clarify and update the existing duty last amended in 1963 to report an accident involving a vehicle on the road. The main changes are there is no longer a duty on the driver to stop if the only damage caused by the accident is to the driver's vehicle, provided, of course, that no person is injured or other property damaged and no horse, cattle, ass, mule, sheep, pig, goat or dog is injured. Except when the duty no longer applies as described above, the driver must now stop if the vehicle causes injury to a person, damage to property, or injury to animals mentioned previously. However, the circumstances in which the accident must be reported to the police are updated and clarified. There is no duty to report such an accident to the police if the driver gives his or her name and address and other specified information, such as insurance details, to any person who has reasonable grounds to ask for it. However, if no one asks for the information or the driver refuses to give it on request, the driver must report the accident to the police. The provision enabling a person who could ask for the information to decide whether to ask for it or instead require the driver not to move the vehicle and report the accident to the police is removed. The provision setting out a reverse burden of proof of special defence is removed. This is the provision which enables a driver who has failed to stop to avoid a conviction for such a failure, or if he or she can prove to the court that the failure was not done with the intention of avoiding any criminal or civil activity for or arising out of the accident. It is considered that this provision is no longer appropriate because it is rarely used and would defeat the purpose of the article. So Regulation 3 amends Schedule 3 of the law, which sets out the offences in respect of which there is no power for a centenaire to levy summarily a fine of £200. Currently, under that article, a centenaire has no power in respect of the current offence of failing to stop and report an accident under Article 52. This remains unchanged. However, the schedule is amended so that the centenaire does have such power in respect of the new offence of failing to stop to report an accident involving a cat. So finally, Regulation 4 sets out the title of these regulations and provides that they will come into force 7 days after they are made. I will finish by thanking officers of the Infrastructure Department and Law Officers Department for their work drafting these regulations, and I would ask members present to support this proposition with the same unanimous support given to P30 2019. So I make the regulation.
Thank you. Are the principles seconded?
Yes, sir.
Does anyone wish to speak on the principles? Yes. Deputy Masson.
Thank you, sir. I would just like to thank the Minister and the Department. This, in fact, has gone slightly further than the proposition, which I know, being in contact with the Equal Rights for Cats group, Jersey, have welcomed, and I know that the departmental officers have been in contact with the group to gather their views, sir. From their perspective, this is a welcomed move. It goes further than just the consultation that they asked for, and the Minister has seized this issue and has driven it even further. So that is very much welcomed by that group. Sir, I would just like to just to say, obviously, I was able to bring this as a proposition to the Assembly and gained support from the Council of Ministers in order to back that. And in particular, I'd like to thank the Treasury Minister, Deputy Pinnell, and the Deputy of Grouville, who were very strong in that meeting in support of my proposition. But also, sir, the praise must go to the petitioners who organised the main e-petition and managed to trigger over 5,000 signatures, which underlines this proposition. So this is a great demonstration for democracy. It also shows that the e-petition system can work well, and I'm sure Deputy Wickenden, who brought that forward, will also be able to take a bit of credit for that. So in addition to this, I echo the Minister's thanks to the departmental officers and the law draftsman or draft person nowadays. I don't know which one's PC, but to those individuals as well, because I know there's been a bit of toing and froing in order to get this through, and especially with regard to being in the pandemic and still being able to prioritise this piece of work, which wasn't in any ministers' many manifestos, in order to still produce this term. And whilst it has been quite a lengthy process to get here, in competition with all the other law drafting aspects and other departmental priorities, can I just thank the Minister for championing this particular issue on behalf of many islanders who want to see this, and of course their beloved pets. Thank you, sir.
Thank you. Conatable and Brillard.
Thank you, sir. And I would first of all like to say, before I say anything else, that I'm in full support of the principles of P30 2019, but I'm particularly concerned as a result of discussions with my centenaires as to the practicality and the ability to police the proposals as before us today. There are several questions brought up, and I'll just briefly discuss them, because I think based on what I've been told, the panel has an obligation to consider it further, and we'll come to that in due course. I would ask the Minister what the obligations on a motorist are if they hit an animal. And it is laid out in Article 52 of the 1956 law. I would ask him, why were cats left out of the original list? And we all know there is a fundamental difference between cats and other animals on the list, in that humans are responsible in the law for all the listed ones. And there are reasons for that. Likewise, sir, should this be restricted to motor vehicles only? A bike, an electric scooter, a skateboard, or a hoverboard would be able to do a lot of damage to a cat. So I think we need to look a little bit further into that. We might also try and identify what might constitute a reasonable belief of a driver, and more importantly, from a policing point of view, what would constitute a reasonable excuse. And there are lots of excuses that could be put forward. So, should a driver be, well, we're told it should stop the vehicle as soon as it's safe and reasonably practical to do so. As soon as safe is easy to define, but or reasonably practical, less so. And that, I think, needs further investigation. Then there is the question, sir, of the person who is responsible for the cat. Without identifying ownership details on the cat, with no register, how is a person supposed to work out who is its owner? And which they may have only caught a glimpse of it as it receded in the rear view mirror. Then a person or a body seems to specify the JSPCA, or well, it doesn't specify the JSPCA. The innuendo that is that it does. Ought we to be more specific on that, and ought that body to have proper documentary abilities to work within GDPR and such like? That seems to be a little bit of a loose end. Once again, sir, the fine level is certainly significant, and level 3 is, I understand it, a fine up to £10,000, being the maximum, of course. But whilst I understand the issue of injuring a cat is highly emotive, but is this fine perhaps proportionate? And I would question that. A further issue says that penalty provision would not have to be so clumsily worded, and if this applies even more to Article 52(6), if it was the paragraph which followed the instruction of what to do applies later, it could be redrafted in a simpler way. So, sir, whilst, as I indicated before, I am fully supportive of cats being protected, I think we need to work a little bit harder on the detail. Thank you, sir.
Thank you, Conatar. Does any of them wish to speak on the principles? If not, I call upon the Minister. Senator Pallett.
Thank you, sir. I'm going to speak very briefly. I think first I want to thank the Minister for bringing this forward so quickly. I berated him on the last proposition, but I want to thank him for bringing this forward as quickly as he's done, and thank him for the work his officers have done. I think the obligations on drivers are quite clear in the report. I think it's, for me, I think it's not come a moment too soon. I've seen firsthand the devastation that it can bring to a family or an individual when they lose their cat in a road accident. And I think it's bad enough to have the animal killed. It's even worse when you lose it and you don't know what's happened to it. So as a member of the board at the JSPCA, I'm really pleased now that there is a responsibility on drivers to report if they believe that they've hit a cat or a dog or any of the animals that are listed. There are lots of scenarios I think that you could bring up around, whether a driver knows whether they've hit an animal or not. I always take the safety first approach, to be honest with you, and much of that's down to my wife drilling into me that all animals are sacred, and I think they are. Is that if I hit anything, doesn't matter whether it's a rabbit, a squirrel, a small animal, If I can stop, I stop and I move it off the road, because I think that's the right thing to do. I don't know whether it's a cat or not, and I think the more of us that do that, the better. I think it's important to remember that we're not dealing in terms of, I think, responsibilities for the police and the whether it's going to be an onerous process for the police. We're not dealing with hundreds of cats here. We're probably dealing with, I don't know how many get killed each year, but it's probably in the tens rather than the hundreds. Is that every cat is someone's pet? Every cat, every owner is going to really feel it if they lose their cat. So I'm fully supportive of what's been brought forward. I know some may say, and I excuse the expression, but it's overkill. But it's not. It's actually the right thing to do. So again, I thank the Minister for bringing this forward so quickly, and I would just ask all islanders to respect it as much as they can, and just remember that all cats are special, all pets are special, and they offer so much to us individually, and we need to make sure that we respect our animals. And as an animal-loving island, I'm sure all members will get behind this particular proposition. Thank you, sir.
Thank you, Senator. Deputy Ward.
Thank you, sir. I just wanted to confirm so I'm clear here. And I completely agree that everyone who drives should take total responsibility if they do have an accident involving any animal, and we have to be responsible. My question is, if somebody is unaware that they've hit a cat, for example, or they see it happen, the cat runs off, are they then responsible to report to the JSPCA? They think they hit a cat and just give the area that it happened in? I think that is the case. I say that because we once had, and it's not anecdotal, but it's practical part of this. There was a cat that was in our garden. We found it had been injured, and we took it to the vet, and it was fine. So there's a good news story at the end of that, and it was fine. But it was obviously been hit by a car. So would that have then been sort of linked to the accident that had happened and that responsibility? I just don't want people to be criminalised who simply could not find what had happened when they had an accident, but are very well meaning and obviously care. So is that them just simply reporting to the JSPCA that they believe they've had an accident involving an animal in a particular area? And there is an issue, and ironically, because you could probably see my view on this, that there are some very large cars on the road, and unnecessarily large cars on the road, where perhaps you wouldn't be aware of an accident like this. So would they be reported, and if so, and they were told, is there a difference to say, I genuinely did not know this happening, perhaps due to bad weather, etc., etc., even with the best intentions in the world? It's just a question of practicality of how this works. But overall, I do support the idea that we have to look after animals as we drive around. I totally agree. Thank you, sir.
Thank you, Deputy. Senator Farnham.
Oh, well, thank you, sir. I'm just pleased to follow the last two speakers, and just from a personal perspective, sir, 2 weeks ago, last Saturday, my little cat Coco was run over and killed outside of our house. And well, the driver, it was a genuine accident, and the driver took the trouble to collect Coco and wrap her up and make the necessary inquiries and bring her home to us. Unfortunately, not all drivers are that considerate. And I don't want to really dwell on it other than to say that we must approve this, sir, because it will help, I think, focus people's attention on the importance of such sad incidents. And after all, they do say that you can judge a nation on the way it treats its animals. So this is overdue, and I would implore members to support it. Thank you.
Thank you, Senator. Deputy Tadia.
Thank you, sir. So first of all, I think I want to congratulate Deputy Masson, who I know has pushed for this for quite a long time, and also the petitioners, as it's been said, that they've really led on this. And I think it's something which we were, when we saw it, we were like, yeah, why is this not already in the law? Of course, cats need equal protection compared to dogs, for example. So I'm really pleased that we're in a position where this has come to the Assembly today. I do have to say, it's extremely long that it takes to get even the most basic propositions, and you know, I know that things can have complexities which are hidden, but if such an obvious proposition takes so long to go through law drafting and so long to actually get put into law, then what about other things? It seems that again we have a system of government which is in complete paralysis almost, and you know, as a dog lover, but generally I love all of God's creatures, sir, it's good to see that the inequality that has existed between cats and dogs has been tackled by this government, that they've managed to close the inequality gap that did exist previously, even if they failed to get to grips with income inequality, and they're presiding over, again, complete inaction when it comes to areas of our community where the divides are only increasing. Really important for.
We can't hear anymore, Deputy. Perhaps, have you finished?
Perhaps. Can you still hear me?
We can hear now, yes.
Yeah, sorry, sir. Don't know what happened there. There's a technical question. I know that the original proposition asked for the collisions to be reported to the JSPCA, and that's why this is being brought back in this way. I guess the concern I've got, it's not because they're not a competent or august body. They clearly, in many ways, are the right people to report it to. I'm just concerned that there isn't an automatic statutory reporting mechanism that would take place to the police. And I understand that one of the issues previously was that and understandably, the police were saying, like, look, we don't want to be inundated with calls about animals that have been hit on the road when there's very little we can do about it. So my question is that if say in a year's time, in 2 years' time, a member of the public through an FOI request or a member of this or a future assembly wants to ask how many collisions there have been in the last year, will the minister have that information ready at his or her fingertips to give that individual an answer straight away, or not? Because I think it's important that we do have access to that and know how it's being administered as well, and to make sure that the JSPCA have any relevant support that they might need. And it may well be that, you know, there should be some kind of modest grant that is given to the JSPCA, and I know that some parishes, if I recall, already give grants to the JSPCA, probably because they're mindful of the good work they do and the synergy there is in terms of the management of our roads and the safety of our animals. So just some initial thoughts on that. Thank you.
Thank you, Deputy. Does any of them wish to speak on the principles of these regulations? Accordingly, I call upon the Minister to reply. Minister.
Thank you, sir, and I thank members for those questions. Deputy Masson, I thank him for his kind words. The Constable of Sombrelard, what are the obligations? Why cats? I believe I've got written here. Basically, originally it was one of liability. Should, for instance, a horse run into a road or cause a collision, or indeed a very large dog cause a collision, a road traffic collision, then there would be some liability on the owner of the animal. This would not apply to a cat, by the very nature very, very small, and they wouldn't come under that. So it was one of liability. They were left off originally. JSPCA, a lot of cats have collars or chip. Should a cat be hit and run off into the bushes? I mean, sadly, if a dog is hit, the dog is normally lying there or very close. If a cat is hit, sadly, they run off. Even if it's their final moments, they will run away. So if the event is then reported to the JSPCA, I mean, the person who may have hit the cat can look for it and point out to the JSPCA where the cat is, or if it disappears altogether, And sadly, if it's terminal, then if someone has lost a cat, they can actually bring up and say, oh, hello, my name is Mrs. Lamarco, I live at Rue de Pré. My cat disappeared night before last, and they can check their records. Oh yes, we had a report of a cat here, here's a description, with a description, and it's maybe lying in the bushes somewhere. At least the owners would have closure, and if the cat was hit and then later found. I mean, hopefully the cats are found and all is well. Where are we? Senator Farnham, sorry, I'm very sorry you've lost your cat. People who are not animal owners don't realise they're members of the family. That I'm not a cat person, I'm a dog person. My Spanish rescue dog is lying to my right here, fast asleep. Yes, Deputy Tadier, liability. Yes, we don't want to overburden the police, and the JSPCA are willing to undertake this task, and we thank them for that. So whatever we can do to make life easier for people, we're more than happy to go along with that. And if there are no more questions, sir, I make the regulations in first reading.
Thank you.
So there is a clarification that the Minister didn't answer one of my points.
Which was?
So I asked about the will the Minister, who in future, have access to the information at her fingertips if she gets asked a question about this, about how many cats have been hit?
We could ask for a report from the JSPCA of the number of cats that have been reported as injured, but if it's not reported, we'd have a lot of trouble getting that data.
So in further clarification, would the Minister clarify that it should be possible and that he will actually make sure that that information is just passed on automatically through a reporting measure that's been set up every year?
We can ask for that, so that's not a problem. Also, we can cross-reference it with cats that have gone missing, if that again is reported to the JSPCA to see how they match up, which will give us some reference to how the reporting is going, sir.
Thank you, Minister. In a moment, the Greffier will add a vote into the chat channel of this meeting. He has done so, and I ask members to cast their votes on the principles.
Up to 37.
Up to 31.
Up to 37.
If all members are opportunity of casting their votes, I ask the Greffier to close the voting on the principles. The principles have been adopted unanimously. 39 votes on the link and 42 votes in the 3 votes in the chat, making a total of 42 votes for and no votes con. Colin Harbison Brillard, does the Environment, Housing and Infrastructure panel wish to scrutinise this matter?
So in the light of comment from the police, we feel we ought to, yes, sir.
Accordingly, the matter will be deferred under Standing Order 72.5, and a date must be set at which the second reading will take place. Do you propose a date? Yes, it must be no more than 4 meetings' time. I think that's the 4th of October. So you propose to, so the second reading will take place on the 4th of October at the meeting that takes place that week.
Yes, sir. Thank you.
The next item of public business is the States Members Remuneration P40 lodged by the Privileges and Procedures Committee, and I ask the greffier to read the proposition.
The states are asked to decide whether they are of opinion: A, to refer to their acts of the 25th of November 2003, the 22nd of June 2005, and the 12th of June 2012, in which the states established the States Members Remuneration Review Body and agreed its terms of reference, and to agree to rescind those acts and disband that body. B, that a new independent system for the setting of States Members' remuneration should be established based on the following principles. 1. The state should set the overall framework for the setting of States Members' remuneration, but should have no role in decisions about the level of remuneration. 2. Propositions to alter the level of remuneration of States members should not be permitted. 3. Members' pay should be linked to an index. 4. The Privileges and Procedures Committee should commission an independent person or body during each assembly term to review the system, including whether the index being used is appropriate, whether the level at which pay is indexed remains appropriate, and other matters such as payments for members leaving the assembly and different levels of pay for different roles. 5. The independent reviewer should take into account the following principles in assessing States members' remuneration. 1. The level of remuneration should reflect the central importance of elected and accountable people's representatives in the democratic system and the responsibilities and workload associated with the roles they perform. 2. The level of remuneration should be sufficient to ensure that members of the states can enjoy a reasonable standard of living as a result of their position. And 3. Remuneration should be set at a level to attract people from all walks of life to serve the island effectively as a states member, mindful of the financial constraints under which the state operates. 6. The independent reviewer should be under a duty to consult states members in the course of their review, and should be under a duty to consult the Minister for Treasury and Resources on the economic and fiscal situation in Jersey, and to take this into account in making decisions and recommendations on remuneration. 7. Article 44 of the States of Jersey Law 2005, which requires all states members to be paid the same amount, should be repealed to permit the independent reviewer to consider the option of introducing different levels of pay for different roles in the state. 8. The independent reviewer's determination should take effect automatically, without debate in the state. The independent reviewer may also make recommendations for the states to consider in respect of matters which require a state's decision, such as a change to the law. 9. These new arrangements for setting states members' remuneration should be statutory. And 10. The first such review should take place in 2022 and should include establishing the index to which members' pay should be linked. In paragraph C, to request the Privileges and Procedures Committee to bring forward the necessary legislative and standing order changes to give effect to this proposition.
Deputy Alves.
Thank you, sir. This proposition asks members to approve a new system for setting members' remuneration. The proposals follow an independent review of the remuneration process and the work of a PPC subcommittee. In July 2019, the committee presented a report by the States Members Remuneration Review Body, which set out a number of recommendations for States members' remuneration beyond the 2022 election. Although the committee welcomed certain aspects of the review body's report, we had a number of questions about the methodology used and queried whether the arrangements for setting members' pay were in line with international best practice. As a result, we commissioned Dr. Hannah White, Deputy Director of the Institute of Government, to undertake an independent review into the members' remuneration process. We published Dr. White's review in October 2020 and established a subcommittee in order to consider the findings and recommendations made in her report. This proposition follows the work of the subcommittee and proposes that there should no longer be a standing body charged with overseeing members' remuneration. Instead, an independent reviewer should be commissioned to review the system during each assembly term. This independent reviewer would take into account a number of principles in assessing remuneration and would be duty bound to consult with states members during the course of their review. Importantly, this new system will be statutory and therefore clearer and more certain than the current system, which is based on a state's decision from nearly 20 years ago. Dr. White recommended that the states should consider establishing a fixed link between member salaries and an indexed or comparator. We do believe that members' pay should be linked to an index, and it would be the responsibility of the independent reviewer to consider whether the index being used is appropriate and whether the level at which pay is indexed remains appropriate. Although we agree that the states should set the overall framework for states members' pay, we do not consider that members should get involved in decisions about pay levels. In Dr. White's report, she makes reference to the fact that Jersey is the only jurisdiction in which members can play a part in the process of setting their own pay if they choose to do so, by lodging a proposition seeking a debate, and she recommended this option be removed. We agree. Dr. White also recommended that states members should take a view on the introduction of differential pay, which was also recommended by the states members' remuneration review body. Let me be clear. PPC did not reach a view on whether or not differential pay should be introduced. Members of the committee have a range of views for and against. However, we believe that it would be preferable for the Assembly to reach a decision on the principle of differential pay as part of this debate, and I will therefore be asking for a separate vote on that part of the proposition. If members agree that Article 44 of the state's law should be repealed, it would be for the independent reviewer to decide whether to introduce differential pay and to what extent. If members accept this proposition, the committee will bring forward the legislative and standing order changes necessary to implement the new system, so it is up and running as soon as possible after the election. I'd like to take this opportunity to thank the subcommittee for their work on this matter, and I would also like to thank Dr. White and the members of the States Members Remuneration Review Body for their work over the years. I move the proposition.
Is the proposition seconded? Thank you. Does anyone wish to speak on the proposition? No indications in the chat yet of anyone who wishes to speak. Constable Brillard.
So yes, I think it's incumbent on us to speak. It's I suppose one could argue that no states member would vote against this, but it would be interesting to understand how PPC intend to take on board public perception of states members' activities and the expectation of what they may be paid so to do. Thank you, sir.
Thank you. Do any other members wish to speak on the proposition? Yes. Senator Ferguson.
Thank you, sir. Yes, I query the fact they talk that the president of PPC talks about a single reviewer. I think that perhaps just one person on their own is, if that's what is in mind, I think it needs to be a bit broader than that. And the business about differential pay, I was in the States when that was actually passed. It was passed on a proposition by Senator Stuart Sivray because of the possibility of, people hanging on to their position because they didn't want to lose their extra pay. And, this sort of kissing goes by favour. And therefore, it was felt to be fairer just to leave it at everybody's paid the same. I throw it in for what it's worth. I agree that it's not a good idea for us to fix our own pay, because the public perception will be that, here we are and having problems recovering from COVID-19 and so on. You know, people are finding it tough, and we're busy talking about our salaries. Not altogether, you know, good for perception. Thank you, sir.
Thank you, Senator. Senator Mezek.
Thank you, sir. And I'll try to make the points as briefly as I possibly can, because I too don't think it's a good look for politicians to be debating their own pay. But of course, this proposition is necessary because it seeks to take us to a better position to resolve any further considerations about states members' pay, moving away from the system we currently have, which quite clearly is broken. I don't think the remuneration review body has carried out work in the way that it ought to have, certainly in my time as a states member, where they haven't sought to investigate what it is exactly that states members do and what the day-to-day job involves, which is quite a bizarre state of affairs. And I think that pretty much everything that PPC is proposing gets us to a better position, and taking away the ability of members to step in and affect the implementation of recommendations on pay is the right thing to do as well. So I'll vote for almost all of this. But I have just said almost. There's one part which I won't be voting for, and that is, of course, the part that Senator Ferguson has just referred to, relating to removing Article 44 of the States of Jersey law, which is the bit that mandates that states members must all be paid the same. And I do so with regrets, to be perfectly honest, sir, because in all honesty, I do think that states members should be paid different amounts depending on what roles they hold. I do think the Chief Minister should be paid substantially more than he currently is. I think ministers should get an uplift. I think certain other roles as well ought to get that because of the responsibility that comes with them. But I can't justify voting for it now under the current government system, because without a full party system and without equal votes in our voting system, and even though we're moving to a better system at the next election, it's still not close to perfect, and we'll still have great inequalities in voting power. I think differential pay risks actually becoming deferential pay, where with a chief minister with the power to dismiss ministers will have I use the term blackmail, sir, but I'm talking about it in a hypothetical context, of course. But another chief minister in the future who wanted to pressure potentially rebellious ministers to vote a particular way would have a tool at their disposal which would threaten that minister with a substantial pay cut if they didn't toe the line. And I think, sir, that in a party system, that's not so bad because the ministers are all elected together on a joint manifesto. And so whether a member serves in government is down to their competency rather than their political affiliation, because the party can simply reshuffle who they have in ministerial roles and they'd still be working to the same manifesto commitments. But this puts us in a situation where a member can serve in government with their own personal manifesto that they were elected on, that has particular commitments and statements of their policy positions, get elected into a ministerial role, and then have pressure put on them to forget their election commitments and promises, to put those aside and instead toe the line with the rest of the government. And if they rebel too much or they're not prepared to toe that line, the Chief Minister will have the ability to say, you're either voting as I tell you to vote, or I'm sacking you as a minister and say goodbye to a large part of your income. Now, you'd hope that members would be strong enough not to fall for that, but it's quite a sacrifice to ask members to make, that if they have to make a decision based on their conscience and integrity, that they can face blackmail based on their income for that. I think that situation would be very, very wrong. And I think that our current government system doesn't put safeguards in place to make that less of a risk. So I won't vote for it on that basis, even though in the future I would support a move to that system. But the other argument that I think is sometimes used in support of differential pay that I think doesn't make sense, and I've seen this in the media recently, is the idea that the salary level for politicians is somehow putting off high caliber potential candidates from coming forward to put their name forward as candidates to this assembly. And so we need to give a massive pay increase to those with the most responsibility in our political system, and that will entice people to put their name forward for politics. And I think that's ridiculous, because when you stand for election, you have absolutely no idea that you'll get a particular role after that election, because it depends how the public vote for the rest of the assembly, whether you'll end up with political support to take on a ministerial role or a senior committee position or what have you. And so in actual fact, what it will do is it will give candidates complete uncertainty about how much they'll be paid after an election. It will be between relatively low amount and potentially a very high amount for the Chief Minister. So the idea that pay uplifts for the senior roles will entice people to stand for election strikes me as nonsense. And especially, I think, when you combine that with the fact that if you're doing this job properly, it's a full-time job. And if you, even if you're a backbencher or you don't have a senior committee role or ministerial role or whatever, if you're really making the most out of your position, bringing items to the assembly for debate, getting stuck in with constituency work, it's a full-time job, and you shouldn't really have too much time to be able to do a job on the side to supplement your income. And even if you were doing that, then of course it makes you more likely to be at risk of potential conflicts of interest as well, which is less healthy. And so I think a lower rate for those would encourage politicians to be part-time politicians, and that's not what the island wants. We need a decent set of full-time politicians working for the benefit of the island. So I understand why PPC have brought that part of the proposition forward. I don't have a problem with having a debate on it, but I'll vote against that particular part and think that the work that the new remuneration reviewing procedure works ought to work within the framework of maintaining Article 4 of the States of Jersey law, understanding that all states members for the foreseeable future until we get more democratic reform ought to be paid the same, so that there's no risk of blackmail, so that there's no risk of members becoming deferential to those who determine how much they get paid, and that we continue to be equals in this assembly because we're elected at the ballot box as equals. Anything that happens after that is not from direct input from the public. And so I will oppose that part of the proposition, but I commend PPC for all the rest of it.
Thank you, Senator. Deputy Higgins.
Thank you, sir. And I'm pleased to follow the previous two speakers. I, like Senator Ferguson, have reservations about one person being responsible for coming forward with proposals on the pay. I think having a number of people with perhaps a diverse background would be far better. Secondly, I will not vote for the repeal of Article 44 and bringing in differential pay. My reasons for doing so is based on observation over the last 14 years. Under the proposals, we say that ministers should get more money because of their responsibility. But ministers have a whole body of civil servants who are supporting them. In a number of cases, their speeches are being written for them. All the background work is being done for them, whereas individual states members have none of that support. No secretarial support, no admin support, no one helping writing your speeches. And equally, many backbench members are dealing with their constituents and their constituents' problems. A lot of ministers don't deal with that at all. or assistant ministers. They seem to put that side of the job to one side and leave it to the others to carry on for them. So a lot of people out there in the island think we only represent our particular districts. I have people from all over the island who've got problems in the areas that I've tended to specialise in. And I know that many other members, backbench members, have people from all over the island. And the workload on some of these cases is phenomenal. And with the lack of resources that an individual backbencher has, then it seems grossly unfair in the one sense to pay a minister more who's got all the support in the world and backbenchers less because they're doing it all themselves. In addition to that, let's have a look at scrutiny. In scrutiny, we have panels that are investigating a lot of things, and we have chairmen. Some of the chairmen are exceptionally good. Others are relying on members on their committees who have either got more knowledge in certain areas or not. And the point is that the way the scrutiny system works, it's all the scrutiny members who are working on the different inquiries that they're doing and reviewing all the evidence. Although, again, the public have the view that the only person who's really doing anything is the chairman. And that's partly because of the fact that we leave it to the chairman to do all the publicity. So, for example, a number of the panels, you find the chairman is constantly on the radio or television or whatever, talking about what's gone on, but the work has been done by, let's say, up to 5 members doing the work. And so it gives the wrong impression. And in fact, one could go so far as to say, if the chairman got more money, would individual members be prepared to put in as much time and effort into doing it? And they don't. So we have to look at what the role of the chairman is in relation to members. But probably my biggest objection to the differential pay is toadyism. I'm not sure if that's a word, but the idea in government is you get people toadying up to either the chief minister or to members of the government for favour and wanting to get positions. Now, over the years, I've seen people crawling for jobs to the chief minister, almost begging them for a job, or essentially doing things like that. So they're so desperate to be a minister that, again, there's a patronage system here. Because the chief minister, and I'm not talking about the existing one, but because the chief minister has so much power and can select who he wants, basically as a member of the Council of Ministers, and normally it'll get through the states, then the power of patronage is amazing. Someone thinking, oh, I need more money, I'd like more money, I'll become an assistant minister or become a minister. And it's the effect it has on voting. I believe in principle, and I believe that we should stand by our views. And I wonder how many people in future will be standing by their principles and standing up for what they believe is right, rather than worrying about whether they're going to get money or not. So I would just say that from a resourcing point of view, ordinary backbenchers earn their money if they're doing their job properly, and they should not be disadvantaged by getting less pay than a minister or a committee chairman. And I just make the one other point too. The only exception I have about someone who should receive more money is the chief minister. Unfortunately, we have the view, or people have the view in the island, that everything the government does is the chief minister's fault. And I'm not talking about the current chief minister. We've had a number of ministers over the years, and I know that they're working exceptionally long hours, and they're expected to know everything that's going on in the individual departments that are being run by the ministers he's appointed. And they can't obviously know it, but they try to, and therefore they've got to be there. So I do have sympathy for whoever has the role of the chief minister. I've seen it in the case of 2 or 3, 4 chief ministers, and I think that could be an exception. But ministers as such, assistant ministers and committee chairmen, no. There are strengths and weaknesses across the board, and I think all members should be treated the same and with equal pay. Thank you, sir.
Thank you, Deputy. There's a question from Deputy Wickington for the Solicitor General. Deputy Wickington.
Thank you, sir. I just thought I'd ask the Attorney General about Article 47 of the States of Jersey law, which is about, because there was mentioned by Senator Mezek about a perception that there could be blackmail of if you don't toe our line, you'll lose your job and you'll lose money, you know, if you don't vote the way I want. But we do have an offence under the law, which is about attempting to compel a states member, and I was wondering if that would be in force in this situation, and if that is a safeguard against such a thing happening.
Forgive me, can I understand what situation the deputy is referring to, please?
In a situation where the chief minister, who has power to fire a minister underneath him, tries to compel the minister to toe a line on a proposition or a vote, or risk losing their job and therefore the money that they get if they had a higher pay because of what's being debated today.
Well, blackmail as an offence is seeking to obtain some form of advantage or pecuniary advantage by threats of well, inappropriate threats. Now, it's a very fine dividing line, isn't it, between what might be criminality on the one hand and what might be the quite normal cut and thrust of political life, where a minister is saying to another minister, I expect your support on this particular proposition, and if I don't get it, then I'll consider, the chief minister might say, I will be considering your future as a minister, because it seems to me if I don't get your support, I don't enjoy your confidence, and that's a red line which I'm not going to tolerate. So I think it's a difficult question. I think you'd want to see something which was plainly much more than the ordinary cut and thrust of political life, and I think what Senator Mezek was describing sounds to me more like the cut and thrust of political life than criminality.
Thank you, SG.
Thank you. Conataba St Martin.
Thank you, sir. I am specifically talking to Article 44 of the States of Jersey Law 2005, which requires all states members to be paid the same amount, should be repealed. I really don't agree, and I'm emphatic that it should not be repealed. The Assembly is a body of equals. We all have the same privileges and rights. As a constable, I have the same state's duties as any other member, as well as being responsible for the running of my parish. I take my role as constable and a states member seriously. In the States, I'm a member of the Committee to Conatabs. I'm Vice Chair of the Public Accounts Committee. I'm a member of the Privileges and Procedures Committee. I'm a member of the Diversity Forum, member of Gender Pay Gap, and a member of the CPA Executive Committee. I work hard, I work long hours. I care for my parishioners and my constituents. Am I working less than a minister? I really don't think so. Having a graded pay structure will change the nature of the roles within the Assembly and will drive division. As its core, it sends out the message that we are no longer equal. In fact, some members will be more equal than others because of their titles and are due more financial compensation. The pay we receive is an important feature in enabling a cross-section of the community to stand for election, and there is certainly an argument for raising it to allow for an even greater range of candidates. The fundamental problem with a graded pay structure will simply boost those members who have experience and are inclined to accept the gift of the Chief Minister or think along the same lines. Indeed, the Chief Minister will have an additional tool to hold over the ministers to accept the government line and to vote along with the party whip. A minister having a disagreement will have to consider the loss of income as part of a resignation decision, and believe me, this will happen. Even for those members, and there is a surprising number in this Assembly for whom the salary is not a necessary incentive, several of the government fall within this category, and yet we are proposing to give them more. How are we to measure the work of an Assembly member? Are we saying that it is more important to be in the government in a management role, or is scrutiny more important in holding the government to account? Is constituency work not equally as important? I would also argue that this is a step in bringing in a board of directors structure to the government, which is wholly not appropriate. The requirements for business and the government are different, with good reason. And whilst there's certainly an overlap, there is also marked differences, elections, for example. If such a measure as differential pay is adapted, then it is very reasonable to say that reward should be based on achievement or meeting targets. Are we all going to have targets to meet? For example, we could say that 50% of a minister's bonus, extra pay, is based on achieving carbon reduction targets. Obviously, this is clearly a step too far. It is one that is perfectly reasonable under the logic that is proposed. For the reasons I've given, this part of the proposition, because it targets a large proportion of the Assembly, does not make sense. It is simply rewarding people in a somewhat arbitrary manner. We could just as well reward those who ask lots of questions, or bring propositions, or sit on a number of committees, or better still, sit on more committees than others, or wear brighter colours whilst undertaking a number of roles. This is not democratic, and I will not be voting for it. It is arbitrary and divisive. Thank you.
Thank you, Conor Tarb. Deputy Southern.
Yes, sir, and I'm looking forward to seeing all the bright colours as of next time, next session. The argument hasn't changed. Stuart Surveyor was right back then when he said we shouldn't have differential pay. I fundamentally agree with that, and I don't think we made enough development of a true good democracy in our structures yet. So for the moment, for the arguments that have already been said by several now, I would be voting against withdrawal of Article 44.
Thank you, Deputy. Deputy Hergera.
Thank you, sir. I too am a member of PPC and would be voting against Article 44. Nobody knows what we all do. There's 49 of us in this Assembly, and no one knows what each one does in relation to constituency work. No one knows how hard we work outside of this Assembly. Those of us that are in scrutiny obviously get less support, although the GREF do support us as much as they can. Resources are often thin on the ground, unlike those maybe in a ministerial role or the Chief Minister. So no one actually knows what others do. It's interesting actually what Deputy Higgins says, because I may be very different to others. And I've always considered, even though I sit as the chair of the health panel, I've always thought that the team I have, or the team that we all work together, and I very much appreciate that I do not earn more money or should not earn more money than any of those that sit on the panel with me, because they all work as hard as I do, and we very much do everything as a team. We work well together, we communicate together, and we provide and do as much work as we can in relation to scrutiny. And there's much evidence of that from the health panel. From my perspective, this is a step too far, and I would not support differential pay, because I think as elected members, we all deserve and earn the money that we get, and we should remain as equals. Thank you, sir.
Thank you, Deputy. Deputy St Mary.
Thank you, sir. And I have two simple points. The first is that two members have already referred to the there being independent persons if that was an individual, and it would help, I think, if the deputy, when she sums up, could advise whether under paragraph B4, which refers to an independent person or body, she does anticipate that there will be a body rather than one individual giving that advice. And the other matter, sir, is one which you might be able to give me guidance. Reference would be made to Article 44 and a vote being taken independently. That does, however, interact with the earlier provisions of the proposition. In particular, B4 refers to different levels of pay for different roles. 5.1 refers to workload associated with the roles they perform, and to as a result of their position. If the clause as to Article 44 was repealed, does that take out of the reviewer's brief, as it were, the necessity or even ability to consider different pay structures for different roles? Thanks.
Well, yes, you raise a good point there, Deputy, in relation to the possible interaction between Roman 7, which deals with the repeal of Article 44, which the proposer has indicated that she wishes to take separately, and other parts of the proposition, in particular 5 Roman 1, which, as you point out, does say that something to be taken into account would be the workload associated with the roles that members perform, which on one view would appear of itself to envisage possible differential pay. But I think that the decision of the Assembly, if this is a decision of the Assembly, not to repeal Article 44 would preclude that sort of thinking. So the provisions of Roman 5, 1 in brackets I've just referred to would have to be read subject to the fact that the Assembly had decided not to repeal Article 44.
Thank you, sir. But for clarification, that the independent body would therefore not even comment on the advisability or otherwise of a scale system. Well,
It might comment on it, but depending on what the legislation finally said, but that comment would have no effect because the Article 44 provision would remain in place, and there would be no way of having differential pay having regard to that provision.
Thanks, sir.
Yes. Deputy Morell.
Thank you, sir. Don't want to repeat any arguments that have gone before, so I just wanted to highlight something I think is a deficiency in the proposition, and that is with regard to B8 in terms of the Roman numerals 8, where the independent reviewer's determinations should take effect immediately without debate in the states. Independent reviewer may make recommendations for the states to consider in respect of matters which require a state's decision, such as a change of the law. Whilst I have no objection to or the determinations taking effect, what I find is deficient and what is lacking is any requirement on the independent reviewer to explain the reasoning behind the levels that they have decided upon. I don't think that it should ever be the case that an independent reviewer should just state a number or series of numbers and that be fixed. I feel that they should explain their reasoning entirely, because otherwise you will end up with real problems with having faith in the system, because it will appear arbitrary. And so whilst the proposal before us has room for consultation with the Treasury Minister, with states members, it doesn't ask or doesn't say that the independent reviewer has to explain their determinations, and I feel that that is deficient. I must ask as well, I'm not sure I didn't fully understand or didn't fully hear the Deputy St Mary's query, but Article B4 in this Roman numerals 4 obviously talks about leaving the Assembly in different levels of pay for different roles. So again, I question whether if Part 7, which refers to Article 44, is rejected, then I question whether B4 would still stand. That's for others to decide. Thank you, sir.
Thank you. Senator Farnham.
Thank you, sir. I don't think there's a single member of this Assembly that does the job for the money. However, I think that the money does enable states members to do the job, and it's only probably, I think, about 20 years since remuneration has been available to states members, and when it was introduced, it was voluntary. There's been some interesting points made. The Constable St Martin made an interesting point, and that brings up the issue of the connotabs, and the connotabs are very, very busy people, because not only do they have their responsibilities and duties in the States Assembly, they also have to run their parishes. But a previous debate, well, I'm not sure if we've had a debate on this, but I know it's been discussed, if not in the Assembly but behind the scenes, is that the fact that connotabs are arguably be remunerated by the taxpayer through their seat in the States for carrying out work by the parish, and perhaps that's something that each parish has to consider individually, especially as the electoral system evolves. I don't know of a single organisation in the world, I couldn't name one, that pays all of its members, all of its workforce exactly the same pay. I can't actually think of another parliament or assembly that does. I might be wrong, and I'm sure members will point that out, that does that either, and that's for a very good reason, which I won't articulate on this occasion. Having said that, I'm not particularly, I don't have a very strong feeling on it, but by saying in principle, members saying that they do not agree that members should not all be paid the same is actually saying that the Chief Minister should be paid the same as every other member. The head of scrutiny should be paid the same as every other member. I'm not sure we should be looking to tie the hands or restrain anybody, singular or plural, and I refer to the makeup of that body, so from doing this work. Deputy Morell may raise some interesting points that might need clarification and perhaps refining. In relation to, just going back to where I started about, I don't think any of us do this job purely for the money, but it does enable us to do the job. I believe that the level of remuneration is certainly a big consideration to islanders when they consider whether they might put themselves forward for service to the island in our States Assembly, because many islanders with commitments, and we know family financial commitments can be large by comparison to other countries because of the cost of living in Jersey and the cost of housing. And you'll find that many people, sir, individuals or parts of families have quite large financial commitments, whether they be mortgages or school fees or other commitments, and simply cannot afford to, would like to, but cannot afford to join the Assembly given their current commitments on the current pay structures. So I would disagree. I would think that is, whilst it might be an incentive, 49 or 50,000 pounds a year might be an incentive for some, it's certainly a deterrent for others. Also, there is the lack of certainty at the end of a term, whether a member has put in 30 or 40 years of service, as we saw with the late Councillor St Clements, or whether they've done one term. Members are treated pretty much the same on departure, although that is beginning to evolve, and at last there is a small but present pension option, and that simply is also a deterrent, and it's probably not, I'm not sure if that is part of the scope of works, but I would argue that these are all important points to address if we are to ensure that this Assembly attracts the right people and is very or truly representative of the islanders that we serve. Thank you. So I'm trying to say, so I would hope members would support this, subject to clarification on one or two of the technical issues, sir, and allow the new body to go off and do this work. Thank you.
Thank you, Senator. The adjournment has been proposed by Deputy Morell. Does any member wish to, that's seconded. Any member wish to speak against adjourning now? No.
Yes, so may I ask how many other members are due to speak on this, and what other propositions are due to be debated?
This is the last matter of public business for this session of the Assembly. Perhaps members could indicate in the chat who wishes to speak, has not spoken yet. I have you, Senator Balwa. I have Deputy Wickenden, Deputy Ward, obviously a response from the proposer.
Sir, I was going to speak on the adjournment, not on the proposition.
All right. Deputy Wickenden.
I was just going to say, I think if we just give it a little bit of time, we can finish up today, and then there'll be no need to come back tomorrow. A couple of people will speak, but surely we can just get this piece of work done, and then it won't interrupt tomorrow.
Well, the adjournment has been proposed and seconded. Does any of them wish to speak on the principle of adjourning now until tomorrow morning at 9:30? In the circumstances, I will put it to the vote and ask the greffier to put a link in the chat as whether or not we should adjourn now until tomorrow morning at 9:30. I ask members to cast their votes on the proposition that we should adjourn now until 9:30 a.m. tomorrow morning.
Okay, I think we've got the job.
Thank you. All members of the opportunity of voting, I ask the greffier to close the voting. And the proposition that we adjourn now has been adopted at 24 votes for, 13 contra, and at least 3 votes for in the chat, making 27 votes for and 13 votes contra. Accordingly, the States stands adjourned until 9:30 a.m. tomorrow morning.